2017. I hereby declare this meeting of the Howell Township Zoning Board to be open. Adequate notice having been given pursuant to the New Jersey Open Public Meeting Act in the following manner. First, on January 10, 2017, a copy of said notice was mailed to the Star-Ledger and the Tri-Town News. Second, on January 10, 2017, a copy of said notice was hand-delivered to the clerk of the Township of Howell. Third, on January 10, 2017, said notice was posted in the office of the Zoning Board and on the bulletin board in the Howell Township Municipal Building, 4567 Route 9, Howell Township, New Jersey. In accordance with the Fire Prevention Code and your safety, please be advised that this facility is designed with 2 emergency exits, which are on your right at the front and rear of the meeting room. Furthermore, smoking is not permitted in the municipal building. Please take note that this meeting is being videotaped for possible future broadcast on Howell Township TV 77.
Thank you, Eileen. Can we have a roll call, please?
Yes, you may. Mr. Amata.
Here.
Mr. Cardelicchio. I have not heard from him.
I haven't either.
Mr. Mertens.
Here.
Mr. O'Donnell.
Here.
Mr. Posh.
Here.
Mr. San Clemente.
Here.
Mr. Turk.
Here.
Mr. Bloom.
Here.
Chairman Nansen.
Here.
You have a quorum.
Thank you, ma'am. Could we all stand for the Pledge of Allegiance? Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Mr. Tropoli, would you mind swearing in the professionals, please?
Record should reflect that Mr. Soppe, Mr. Mallon, and Mr. Howard have all been sworn for the evening.
Thank you, sir. Approval of minutes, regular meeting, August 14th, 2017. Eligible voters, Armada, O'Donnell, Posh, Nansen. Do I have a motion?
Motion to approve.
Motion by Mr. O'Donnell,
I'll second it.
seconded by Mr. Armada. Can we have a roll call, please?
Mr. Amata.
Yes.
Mr. O'Donnell.
Yes.
Mr. Posh.
Yes.
Chairman Nansen.
Yes.
Minutes are approved. Thank you.
Regular meeting, August 28th, 2017. Eligible voters, Armada, Cardelicchio, Mertens, O'Donnell, Posh, Turk, Bloom, Nansen. Do I have a motion?
Motion to approve.
Motion by Mr. O'Donnell,
I'll second it.
seconded by Mr. Armada. Can we have a roll call, please?
Mr. Amata.
Yes.
Mr. Mertens.
Yes.
Mr. O'Donnell.
Yes.
Mr. Posh.
Yes.
Mr. Turk.
Yes.
Mr. Bloom.
Yes.
Chairman Nansen.
Yes.
Motion carries.
Regular meeting, September 11th, 2017. Eligible voters, Armada, Cardelicchio, Mertens, O'Donnell, Posh, San Clemente, Turk, Bloom, Nansen. Do I have a motion?
Motion to approve.
Motion by Mr. O'Donnell,
I'll second it.
seconded by Mr. Armada. Can we have a roll call, please?
Mr. Amata.
Yes.
Mr. Mertens.
Yes.
Mr. O'Donnell.
Yes.
Mr. Posh.
Yes.
Mr. San Clemente.
Yes.
Mr. Turk.
Yes.
Chairman Nansen.
Mr. Bloom?
No, we have 7 already.
Oh, okay.
Thank you.
Yes.
Motion carries. Thank you.
Regular meeting, September 25th, 2017. Eligible voters, Armada, Mertens, O'Donnell, Posh, Nansen. Do I have a motion?
Motion to approve.
Motion by Mr. O'Donnell,
I'll second it.
seconded by Mr. Armada. Can we have a roll call, please?
Yes, Mr. Amata.
Yes.
Mr. Mertens.
Yes.
Mr. O'Donnell.
Yes.
Mr. Posh.
Yes.
Chairman Nansen.
Yes.
Motion carries.
Thank you. Any vouchers?
No vouchers.
Correspondence?
Yes, we do have some correspondence, and it concerns case number BA 1612 for New York SMSA, also known as Verizon Wireless. And I guess Jack can maybe explain it a little better for the board.
Is that 1612 or 1622?
1612.
Well,
Yeah.
okay, and basically what happened, we've been contacted by the engineering department and the applicant. This was the case of the cell tower up off of Wyckoff Road. Remember the place in the back by the sheds? Couldn't go on the tower. And we approved it. We gave them approval of certain permits and any permits by NJDEP. And the comment from the engineering is they would like us to include the floodplain permit in the township floodplain permit We didn't specifically state it, but we made them get a state permit. So he'd like us to amend the resolution to just say that the township floodplain permit could be issued if they get the state floodplain permit. It's kind of implied that they get it, but we didn't put the name of the township floodplain permit in the resolution. So he wants us to change the resolution or amend the resolution, just include that title. That's basically what the comments are.
They've already received the NJDEP.
That is correct. They already have the NJD permit. They have all their permits. The problem is they can't get a building permit because they don't
Okay.
have a township floodplain permit.
Okay,
Mr. Chairman,
yes, sir.
this is a technical amendment to the resolution. If the board would refer to page 15, paragraph F, I indicated in the conditions of approval that one of the condition was subject to NJDEP issuance of an LOI and flood hazard permit. So I concur with Mr. Mallon, and this is a very minor technical amendment. However, I do believe that the engineering department wants to see a resolution, Mr. Mallon.
That is correct. They would
So-
like us to amend the resolution to include township floodplain permit.
And-
That's why I suggested we do township floodplain permit, subject to the issuance of the New Jersey DEP floodplain permit.
Okay.
This is not subject to an open hearing as far as I'm concerned, but it is subject to a vote of the eligible members. And I'm going to ask our administrative secretary to just read out who is eligible, and then we can put it to a vote if the
Okay.
board, please.
Does the board, before we go there, does the board understand what we're talking about? On doing, okay. This is amendment to the resolution to the Verizon application that we had a couple of months ago, right?
It was actually last year.
October
Last year.
24th.
2016.
Okay,
Right, 2016.
Almost a year.
And the eligible voters, Eileen?
The eligible voters were Mr. Amata, Mr. Posh, Mr. Mertens, and Chairman Nansen.
okay.
Okay, so limited to those members, would there
Right.
be a motion, a second, and an approval?
And what this is just amending the resolution to include the township
Floodplain
permit follows the NJDEP permit, the issuance of that it will be included into the resolution. Do y'all understand that? Okay. Do I have a motion to amend the resolution?
I'll make a motion to amend this resolution.
I'll second that.
Motion by Mr. Amata, seconded by Mr. Merton. Can we have a roll call, please?
Yes, Mr. Amata,
Yes.
Mr. Mertens.
Yes.
Mr. Posh,
Yes.
Chairman Nansen.
Yes, the wording to be provided by Jack and Ron.
Yep.
Yes.
Thank you.
We'll work on it, thank you.
Motion carries.
Thank you. Resolutions, case number BA7, is there any further correspondence?
No further correspondence.
Thank you. Sorry, jumping the gun there.
That's okay.
Resolutions, case number BA 17-01, United Advertising Company. Resolution granting appeal. Eligible voters, Armada, Mertens, O'Donnell, Posh, Nansen. Do I have a motion?
Yes, I'd like to make a motion on case number BA 17-1 to memorialize it.
Okay, motion by Mr. O'Donnell,
I'll second that, Mr. Chairman.
second by Mr. Mertens. Can we have a roll call, please?
Mr. Armata,
Yes.
Mr. Mertens,
Yes.
Mr. O'Donnell,
Yes.
Mr. Posh,
Yes.
Chairman Nansen.
Yes.
Resolution's memorialized.
Case number BA 17-10, Justin Israel Tao. Resolution granting use variance approval. Eligible voters, Carlicchio, Mertens, O'Donnell, Posh, Turk, and San Clemente. Do I have a motion?
I'll make a motion for case number BA 17-10, motion to memorialize.
Got a motion? Do I have a second? Second by Mr. Turk. Can we have a roll call, please?
Mr. Mertens,
Yes.
Mr. O'Donnell,
Yes.
Mr. Posh,
Yes.
Mr. Turk,
Yes.
and Mr. San Clemente.
Yes.
Resolution's memorialized.
Okay, applications before the board. Case number BA 12-13, All Green Lawn and Landscape. Extension of time. Application of All Green Lawn and Landscape is applicant and owner seeking an extension of time on their approvals granted November 18, 2013, to utilize an existing barn structure to store landscape equipment and vehicles.
Good evening, Mr. Chairman. Good evening, Board.
Two. Oh, no.
This is our application for an extension of time. Good evening, I'm William Bajer. I was the attorney for the applicant originally, continuing to represent the applicant. This was a use variance largely for my client who owns a landscaping business to be able to use this property for his landscape company under certain very limited conditions. Internal storage, some vehicle storage, limited to a certain number of bobcats, all laid out in the resolution, which was passed in late 2013. Largely, the use portion of the application, I believe, has been complied with to a large degree. But there was a failure of my client to obtain permits and really have a construction meeting to perform the about $14,000 worth of labor that was required to comply with the resolution. That included a gravel driveway, an apron, and some other site improvements. We've now met with the construction people, and my client, he had gone in, asked if he needed a permit, was told no, but he didn't ask the right question. What he should have said is, this is part of a resolution, what do I need to do? He did not do that. Failure on the applicant's part, certainly inadvertent, wasn't meant out of any disrespect for the professionals or for the board. My client has actually done some of that work, but I believe what needs to happen now is if the board would entertain and grant the extension of time, my client would have a construction meeting, talk to them about what work has been done, maybe opening some of that work up, including the driveway, to make sure it's deep enough, make sure the proper soil materials were used, and then comply with any requirements of the construction department as were required in the resolution. He's prepared to do that. We've had some contact with the engineering department. They've been great about it, about having that meeting, but they wanted to certainly bring it before the board to make sure we were doing it within the confines of a resolution that was still in effect. So we would need a period of time covering the time that's already passed, and then probably another 6 months to allow him to complete the work, get the inspections, close out the bond, and finally finish this process once and for all. So that would be our application here tonight. And Mr. Schwartz, the applicant, is here with me this evening.
Right. Mr. Chairman,
Yes, sir.
in looking over this application and doing the math, I note that what Mr. Bajer actually is asking for is a 3-year extension because you relate it back to the expiration date. So this should be, your application actually should be a request to run it through December of 2018.
The original was December 18 of 2013.
Well, that plus 2 years, 3
And then
more
we need
years.
3
so
from that. That would be
just so-
correct.
Just so I'm clear, you
Yes.
are asking for 3 years.
Yes, counsel, that would be correct.
So
And I believe it'll be done before that, but I think that's probably the safest way
That
to
would
do
be
it.
my recommendation, because if it were 2 years, he would have another month to go, and that would not be appropriate. If the board accepts the rationale for the extension of time, I would recommend that the board consider this as a 3-year extension of time. 3 years to cover the time frame that has already passed, unfortunately. And he has performed as per the testimony, well, the representation, I should say, of counsel.
Right. Matt, do you have anything to say?
No, they've been working with the engineering department, from what I
Okay.
understand. This is the requirement that they put on them to
Okay.
make everything right.
Okay. Mr. Mallon?
Nope, same thing. This would be his, this would be his 3 one-year extensions, though. If
Okay.
you don't finish and you have to come back, then you have to fully advertise the 200-foot list if
Understood.
you ever try to come back for more extensions.
Understood.
Okay.
Okay. Board have any questions? No. What's the pleasure of the board?
I'd like to make a motion to grant the 3-year extension that would end on December, I don't know, what's the date, the 18th? Yes. 2018, so it'll be actually 1 year, even though we're going retroactive.
Correct.
So motion is to grant it.
Was it December or November?
I think it was approved on November, but the resolution was
Was
December.
a month later then, correct? Okay,
Sorry.
just questioning. Okay. Got a motion?
I'll second that.
Second by Mr. San Clemente. Can we have a roll call, please?
Mr. Amata?
Yes.
Mr. Mertens?
Yes.
Mr. O'Donnell?
Yes.
Mr. Posh?
Yes.
Mr. St. Clementi?
Yes.
Mr. Turk?
Yes.
Chairman Nansen?
Yes, I strongly advise get it done.
We will. Thank you guys so much. I
You're
appreciate
welcome.
it. Have a good night now.
You too. Okay, we're gonna do a little swap here. We're gonna switch the cases around. I'm gonna take case number BA 17-13, Stavola Leasing LLC at this time. It's an interpretation of zoning ordinance. Application of Stavola Leasing LLC is applicant, and I Greenway LLC and 2 Greenway LLC is owner seeking an interpretation of a zoning ordinance to determine if a variance or conditional use approval is required for L&L Paving to operate an asphalt plant premises known as Block 177, Lot 62.01, formerly 62 and 64, 89 Yellowbrook Road. Application of Stavola Leasing LLC was originally scheduled August 28, 2017. When it was carried with notice to September 11, 2017. On September 11, it was carried to October 2nd, 2017, with no further notice. October 2nd, 2017, the application was carried to November 13th, with no further notice. Expiration date, December 30th, 2017. Stavola Leasing, you want to come forward, both councils? I want to address councils before we actually get into the case itself. This is an interpretation. I do not want to get into the merits of the actual application that is before the planning board. That's not what we're here to discuss or get into deep testimony on the basis of those. Okay? And, you know, the witnesses, we're here to decide a zoning ordinance, what should happen within that. Mr. Tropoli?
And, Mr. Chair, with your permission, I just want to address the public who may not be familiar with this process. This is an interpretation, which is a legal analysis by the board based on the presentation that council and their witnesses will make. It is a legal decision, and it is not an application, for example, such as a use variance or an application where members of the public may come forward and render their opinions. It's not that kind of application. So this is not public permission, public participation is not permitted, but you're certainly welcome to sit and listen to the legal arguments. But I just wanted the board to understand, as well as the members of the public, that it's your decision and that the public participation is not permitted in these kinds of application. And with that, Mr. Chairman, I'll turn it back over to you.
Okay, sir. Mr. Gazarovski?
Thank you, Mr. Chairman. Mr. Chairman, members of the board, properly, and other expert witnesses. Before we proceed, what I would like to first establish is that getting guidance from both the board as well as Mr. Tropoli to establish the fact that this board is the board that has jurisdiction to hear this application for an interpretation.
Mr. Gazarovski, it's my understanding, and this is under 4055D 70B. As you know, the Board of Adjustment shall have the power to, and I'll quote from Cox, quoting from the statute actually, hear and decide requests for interpretation of the zoning map or ordinance or for decisions upon other special questions upon which such board is authorized to pass by any zoning or official map ordinance in accordance with this act. So is it my understanding, and the board's understanding, Mr. Gazarovski, that you're making an application under that particular provision of the statute, is that correct?
That is correct, and it's my position that it is only this board that has jurisdiction to hear this application.
I can tell you that the board has jurisdiction to hear your application
Thank you.
tonight.
Mr. Chairman, members of the board, my name is Ron Gazarovski. I have offices in Red Bank, New Jersey, I've had the pleasure of appearing before this board on several occasions, and I represent an entity known as Stavola Leasing Co., LLC, who is the owner of properties located at the corner of Fairfield and Route 33. We are here before you today seeking an interpretation, as Mr. Tropoli has stated, and more particularly when one looks at the MLUL under 40:55D-70, powers of the board. We're here for this board to hear and decide a request by this applicant for the interpretation of your zoning map and/or an ordinance which was in play during the year of 2016.
Can I ask, you had stated Stavola Leasing had property at Fairfield in 33?
Yes.
Okay, it's not on Yellowbrook?
I'll get the actual lot and block for you before I leave this evening, but I
Okay.
think, just so we'll be clear on that.
Okay.
So we have before you this question, and I agree with the chairman, as I'm sure you've been advised by the applicant, by rather your board attorney, that this does not have to do with a particular application or the merits of any particular application, but rather this is all about what your ordinance said, which ordinance, of course, has been amended during the year of 2017. I think in the year of 2017, the ordinance was amended. Now, in its original configuration, and what we are seeking interpretation of back in 2016 rather, it listed the permitted uses in what you have identified as the SED zone. And they list as permitted uses under paragraph B, letters A, through W. Those are all of the listed permitted uses. Now, in those permitted uses, beginning with subparagraph H, they refer to a number of activities which would entail manufacturing. For example, manufacturing lumber and wood products, manufacturing furniture and fixtures. Under P, it very specifically says manufacturing stone, glass, clay, and concrete products. Now, for the purposes of this hearing, the two words which we're really focusing on is concrete products. So, under your old ordinance, what was permitted was the manufacturing of concrete products. In other words, it's our position that what that ordinance meant was that you could produce concrete, but you would have to utilize it by making it into a product on that site, such as, for example, one of the prior owners of this property, Kerr Concrete Company, did. They manufactured concrete pipes. Other areas immediately surrounding manufacture concrete blocks, things of that nature. We are saying that it did not permit the manufacturing and sale as a concrete manufacturing plant to manufacture or produce concrete and have it taken off the site with various trucks who then deliver it to other sites throughout the state. In other words, it did not permit the retail sale of concrete, but rather it only permitted the manufacturing of concrete to be placed into a certain product, such as Kerr did, concrete pipes, or head walls, and or the like. Now, when I filed my appeal concerning this, there were a series of 3 letters that were provided to this board by your professionals, and I intend to introduce those letters and also call upon your professionals who are here to give testimony as to those letters and, of course, to establish the fact that they were the authors of that correspondence. Such letter is a review letter which was prepared and signed by Mr. Mallon, John Mallon, who we call Jack Mallon, who is the board engineer, and he gave testimony in his letter on August the 14th of 2017. He then produced an amended letter. But in his letter of August the 14th of 2017, first I would like to have it marked as an exhibit.
It's already
Give a
marked.
copy
It's
to-
already marked.
What?
It's already marked.
It's marked as
It's already in
B3.
In.
It's part of the record right now?
It's marked as B3 on your exhibit list.
P3, am I exhibit?
B3.
B3.
And
Okay,
the
fine.
revised letter is B4, and the planner's letter is B5.
Okay. May I have them distributed to the board?
The board already received them.
Board has to, okay.
Is there
You
anyone?
want them? You want a
Any
copy?
of
All right.
those who don't have them, right?
Yeah, I don't have a computer.
Right. And, Mr. Chair, one omitted matter, well, I know Mr. Butler's at
Yeah.
council table. Can we please ask him to render his appearance?
Sure. Good evening, everyone. My name is Michael Butler, and I represent L&L Paving, who is the applicant at 89 Yellowbrook Road. I also represent 1 and 2 Greenway, the owners of 89 Yellowbrook Road. Thank you.
Yeah, I don't have a computer. I already know what it is, so.
Good to see you again. Thank you.
Okay, in that letter, and I intend to call Mr. Mallon to authenticate it, but on the second page, in the first paragraph of the second page, Mr. Mallon, first of all, it's a carryover from the last paragraph on the first page. And on the last paragraph of the first page, he said,
Mr. Gazarovski,
Sir?
which letter?
I'm sorry, do you have a copy of it?
I do. I just didn't know which one you're
August the
referring to.
14th, 2017, it's his first letter. He then has a subsequent amended letter. This is the first letter.
Okay.
In the last paragraph, he states, we note that, quote, manufacturing of stone, glass, and clay products are a principal permitted use in the SED zone, period. Note, quote, and concrete projects, he meant products, it's a misspelling, was removed but previously permitted.
Maybe he meant right.
We then go to the second page, and he follows that by saying, quote, manufacturing of hot mix asphalt is not listed as a principal permitted use or conditional use in the SCD zone, either previously or under the current ordinance. Therefore, a variance is required. That's Mr. Mallon's comment in his initial letter. He then wrote a second letter.
It's 15.
Just for the fees.
Bear with me for 1 second. Now, that letter was dated August the 14th with the reflection that it was amended on August the 15th of 2017, and I trust you also have a copy of that letter, and how has that been marked?
That is marked as B4.
Okay. Now, this letter was really a response to a question which I posed to Mr. Mallon. Now, does everybody have copies of that letter? Because I have additional copies.
I'll take them then
Okay.
to the board, we'll make it easier.
Yeah, making that Fitbit go crazy, huh?
Your pleasure.
Now,
I'm good, thank you.
first page of this letter is identical.
Can I interrupt?
Yes, sir.
What was that, what'd you just say?
Pardon me?
Did you just say that, can you repeat what you said right before everyone was trying to figure out what exhibit we were talking about?
What I just said just a second ago?
Yes.
I think we've had this marked as P4, and I said that the first page of the second letter, the amended letter, is similar to the letter dated August the 14th. This amended letter is dated August the 15th.
You said something just before that.
Well,
And I just want to be clear. Did you say that this letter was changed in response to a question that you, or a conversation that you had with Mr. Mallon?
I understand that. I would represent to the board that this amended letter was the result of a question which I had posed to Mr. Mallon, and he responded with his amended letter. That's what I said.
Okay, just so we're clear.
Okay. Now, on the second page of that letter, what is different, and if you look at the first and second paragraphs, Mr. Mallon repeats what he said in the August the 14th letter. Manufacturing of hot mix asphalt is not listed as a principal permitted use or conditional use in the SED zone, either previously or under the current ordinance. Therefore, a variance is required. He then adds the second paragraph, which states, in addition, the, quote, manufacturing of concrete, end quote, is also not listed as a permitted use, only concrete products, which was removed from the permitted use. So what this really is from Mr. Mallon is an observation as the planning board engineer in reviewing the then existing ordinance.
Jackson, are you testifying for what
I'm
Mr. Mallon?
not testifying, you know.
It sounds like you're testifying as to what Mr. Mallon said and why he said it.
No. I'm referring to what Mr. Mallon said in the letter. I am not testifying, I am not giving you my opinion, and frankly, if you want to object, I understand it, but I think your objection should be addressed to the chair,
Okay,
who will then give me guidance.
Noted,
okay, I apologize for that, Mr. Chairman.
noted.
What was the question to Mr. Mallon?
The question I posed to Mr. Mallon, noting in his letter of the 14th, he only referred to hot asphalt. It was my opinion that in addition to asphalt, it should also include concrete, and he responded with his letter dated the 15th, which says, in addition, the, quote, manufacturing of concrete is also not listed as a permitted use, only concrete products, which was removed from the permitted use. And I would submit to you, this is really, I think, an observation on the part of Mr. Mallon after reviewing the zoning ordinance.
Well, I
Chair.
would ask
I
that the
agree.
board as well disregard that comment. And again, and Mr. Gazarovski not wanting to interrupt your presentation, I think it's fair to say, Mr. Chair, and again, I know Mr. Gazarovski will continue on with Ms. Opte's letter. These letters speak for themselves,
Right.
Right.
period. And
That's why I haven't asked
and the
Mr.
witnesses are available, they will be called, they will give testimony. So I think I would limit and respectfully, Mr. Gazarovski, the side commentary as much as you can, because the
Sure.
letters do speak for themselves, and obviously, there will be cross-examination of the board's witnesses.
Correct.
I'm not seeking to opine or have Mr. Mallon's letter treated as an opinion, but rather it's just simply a statement by him as to what is listed in the zoning ordinance.
Once again, my objection stands.
Noted.
Now, after that took place, I did in fact receive a copy of an unsolicited letter that was sent to the Howell Township Zoning Board of Adjustment by Malvika, M-A-L-V-I-K-A, A-P-T-E, professional planner. Ms. Malvika did identify herself in that letter.
Mr. Chair, if I can object,
Yes.
I think Ms. Malfika is the,
our board planner.
she's the board planner.
Yes.
I don't think it was an unsolicited letter.
Ms. Opte is our board planner.
Yeah, I'm sorry,
Agree.
Ms. Opte.
Yeah, that,
Received a copy of the letter. You know, I earlier said that,
but that's unsolicited?
yeah, I didn't ask you for the letter, I received it.
Well, it's
Part of her review process.
it's our review. That's not an unsolicited letter.
We can move on now.
Okay.
Now, how is that labeled or numbered?
That is listed as B5.
Thank you. And I have additional copies of that as well.
Please.
I know you just hand them there and let them pass it down. Okay,
Personalized, sir.
working that Fitbit, that's what it is.
Thank you.
Thank you again.
Mr. Gazarovski?
Thank you. Now, with regard to these letters, and I will not go into the last letter of Ms. Apte, but rather I'll simply call upon her to testify as to what that letter says. That way, we're not going to be burdened with questions concerning it. I think that when one looks at the ordinance in question, what is important is not only what it says, but what it does not say. And I would submit to you that the crux of this question with regard to the ordinance in question is what it does not say. What it does not say in the ordinance in any place is that a concrete manufacturing plant or a concrete asphalt plant in any sense, be it hot asphalt or the like, does not say that it's a permitted use. And that is reflected in the Mallon letters, and then, of course, you'll have the letter of Ms. Apte, which I will then later walk you through. So our position is that the use of the property in question only permits, under that existing ordinance in 2016, the use of the property for the manufacturing of concrete products. There is nothing in that ordinance which in any way suggests that either a hot asphalt manufacturing plant or even the manufacturing of some type of asphalt product is a permitted use. What then happened was that in 2017, and I believe in July, that ordinance was amended. And the manner in which it was amended is that the words concrete products was removed from that section of the ordinance under permitted uses. So in 2017, for whatever value that has, not only was the concrete plant or an asphalt plant, but in addition to that, even concrete products was eliminated as a permitted use. Now, what I intend to do is to call initially Mr. Mallon as well as Ms. Apte to authenticate those letters and state to the board what they intended to say in those letters. And of course, the board may have questions, and council may have questions or cross-examination with regard to that. But these are two review letters by your professionals. I also intend to call as my planner, Andrew Thomas, who is a licensed professional planner in the state of New Jersey, and he will give testimony, professional testimony, with regard to the intent of and or what those ordinances say on their face. And I think what's important in looking at the ordinance, you cannot place yourself historically back 20 years or 30 years or whatever it may be and attempt to surmise what the governing body may have been thinking of or intended when they passed the ordinance, but rather you have to look at the ordinance on its face and interpret what it means. And we would submit to you that there's no other interpretation other than to say that in 2016, while concrete products, manufacturing a concrete product on that site, such as a head wall, concrete pipe, bricks, block and whatnot, may have been a permitted use, but the operation of a concrete manufacturing plant for the purpose of disposing of concrete off-site was not a permitted use. But more importantly, there is nothing in that ordinance which in any way suggests that any type of a use dealing with the manufacturing and or sale of hot asphalt was either contemplated or permitted. So that's really my opening comments. If council has something to say, we could then, once that's done, move on with the case.
Well, I think you ought to bring your witness forward,
Thank you.
and we'll go ahead and swear him in.
Would it be useful for me to say a few words?
But, yeah, it will be, I think Mr. Butler would like to comment, but before he does, Mr. Gazarovski, before we discuss taking testimony from the board's witnesses, which is, you know, it's a bit unusual, but I understand your point. I think the board needs to hear from your witnesses, because
Exactly.
these are the professionals that they rely upon. And again, they're here, they're subject to cross-examination. And, you know, they're not obligated to make the burden for you in your case at this point. They're here, they've made their letters, those letters speak for themselves, they will testify. And I think the board wants to hear, and again, correct me if I'm wrong, Mr. Chairman.
That's why I want him to swear he's professional in.
Okay, that's my opinion. And Mr. Butler, I'm going to turn it over to you for any comments you may have. Again, I'd like to get into the meat of the case.
Yep.
Let's get the professionals on record. Let's get the testimony out. The board's witnesses are here. If Mr. Gazarovski wishes to cross-examine him, which he certainly is entitled to, as Mr. Butler is.
Sure.
I'll turn it over to you, Mr. Chair.
Mr. Gazarovski, you want to bring your witness
Bob, you have
forward?
no comments?
If I may, real quickly.
Okay.
Okay, I'm not gonna go long, because I know we want to get into the meat of the application, but this is there's a bigger picture here than what was presented by Mr. Gazarovski. What we have here is a competitor, with a bituminous concrete manufacturing facility that's located across.
I thought we started out by saying we're not going to get into the particulars.
I'm not getting into the particular of the
Who my
individual
client is or
case.
isn't is of no relevance.
I'm not getting into the particulars of the case. There is a bigger picture here. This application was filed by Stavola Leasing. Stavola Leasing owns property across the street from my client.
Yeah, but this is kind of irrelevant at this point, what happens off-site, because that's not what we're here for.
No, and I agree, to a point. It's pertinent when, in the past, there have been decisions and findings that
Objection
a
again,
use
counsel's
is permitted.
testifying.
And I'm presenting my opening statements, and I will have certain exhibits marked into testimony.
Noted.
It's important when there are certain decisions that have been made for a period of 40 years or more, saying that the manufacturing of bituminous concrete, the manufacture of concrete is permitted in this zone on properties on Yellowbrook Road, including a property that's owned by Stavola Leasing, LLC. So it is important to understand that there is a bigger picture here. The question before the board is, what is a concrete product? That question has been answered by the planning board for the past 40 years. There's resolutions of approvals that we'll talk about. They've already been entered into the record. That's the one question, is what is a concrete product underneath that ordinance, underneath your ordinance, and how do you interpret your ordinance? Mr. Gazarovski is going to present how he thinks the ordinance should be interpreted. We're going to present how we believe that the ordinance should be interpreted. And it's not just on the face. You have to look at what it says, what it means. You have to give it the logical understanding that it is worth. And you have to look at how it's been interpreted over the past 40 years consistently by a board. I'm not going to belabor the point. I want to get moving. I know there's another application tonight, so I'll let Mr. Gazarovski start with his first witness.
Mr. Gazarovski.
Thank you. Let me call my first witness, Andrew Thomas.
If you would remain standing, please, I'll swear in. You swear the testimony you give this evening will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Good. And sir, may we have your full name, please?
Andrew Thomas.
And you're testifying as a planner, sir?
Yes, I am.
Mr. Gazarovski, you want to qualify your witness, please?
Pardon me?
Qualify your
I
witness?
shall.
Please.
Setting something up right
Thank you.
there. You're out, Mike. Mr. Thomas, if you would, for the board, would you please, is this also
Yeah,
working?
that's working.
Mr. Thomas, if you would, for the benefit of the board, would you please state your full name and where you presently reside?
Yes, Andrew Thomas. I work for Thomas Planning Associates, employed as a professional planner. I have a master's degree in planning. I have more than 20 years' experience in the field of planning. I'm a licensed professional planner in the state. I was licensed in 1994. I'm also a full member of the American Institute of Certified Planners, which is the AICP, and I take continuing education credits to maintain that certification. I have not appeared before the Howell Township Zoning Board, but I have testified before numerous planning and zoning boards throughout the state. I believe I'm qualified in over 60 different municipalities. I am the borough planner for the borough of Farmingdale. Our firm serves as consulting planners for 5 other communities in Monmouth County. And typically, in my planning experience, I've prepared master plans, zoning ordinances, many GIS mapping programs, zoning amendments, park plans, utility plans.
Your education?
I have a master's degree in planning from Florida State.
How about undergraduate degrees?
I have an undergraduate degree also from Florida State as well.
Okay. We accept, the board accepts it. Do you have, Mr. Butler?
No questions.
Are you, Ron? Okay,
All set?
carry on. Yes, sir.
Okay, Mr. Thomas, you were retained by me to provide expert testimony with regard to this particular matter, were you not?
That's correct.
Okay, and as a result of that, you're being compensated for your testimony?
Yes,
Okay. Now, prior to coming here, or prior to testifying this evening, did you have occasion to visit the site?
I did.
On how many occasions?
Twice, and the last one was just over the summer.
Okay. Now, in addition to that, did you order, did you require, did you secure various aerial photographs and other such material with regard to the site in question?
Yes,
Okay, and you prepared a number of exhibits concerning that?
I've prepared some exhibits, that's correct.
Okay, now, in addition to the physical examination and the preparation of some aerial photographs, tell us, if you can, step by step, what you did to prepare yourself for this evening's testimony as far as documents you reviewed, visits to the municipal building, and the like.
Went to the municipal building, prepared some Oprah requests to get some information. I reviewed the ordinance. I reviewed ordinance 01721, which was the new ordinance passed for this zone, passed on July 18th of this year. I reviewed the engineering and planners review letters. As I stated, I visited the site and the surrounding area, and was particularly interested in the uses within the SED zone around that particular site. I reviewed the 2016 application by L&L, the site plan, the notice, the minutes, resolution, and also the previous resolutions on the property. The previous property owner was Kerr Concrete Pipe, and I have some exhibits showing that.
Now, you've listened to Mr. Butler state that perhaps in addition to the resolution for the Kerr site, he was prepared to produce other resolutions as well for surrounding properties.
Yes,
Did you also have occasion to review those resolutions?
I did.
Okay, and you have copies of them with you today?
I do.
Now, you referenced the fact that you reviewed letters from both the engineer as well as the planner. Are those the exhibits that were earlier marked being 2 letters from Mr. Mallon, one of which is dated the 14th of August, the other is the 15th?
That's correct.
And then, of course, also the review letter of Ms. Apte, who is the planning board planner.
That's correct, from August 18th.
Okay. Now, can you describe familiarizing yourself with the site, can you describe the surrounding land uses, and have you prepared an exhibit with regard to that?
Let's mark those exhibits.
Before we do that, Mr. Gazarovski, I just want to put on the record that, really, other than to direct the board to the site, so that the board might understand exactly where it is, to get into the surrounding uses and other uses can prove to be getting to the merits of the case, which I need to caution the board against. So with that, I don't know what you have. I haven't seen them. I don't know what Mr. Butler's opinion will be, but let's proceed. But again, with
That's fine.
caution, with caution, because I do not want the board to get to the merits of the case. This is a legal, as you know, Mr. Gazarovski, respectfully, a legal argument. If these exhibits go toward that legal argument, that's where they should be going. If it's going towards the merit of what's there, what should be there, or what could be there, it really is of no moment.
I understand that, that's
This
fine.
application. Very
So-
good, sir. Thank you.
Okay, let's then, Mr. Thomas, if you would, focus on the ordinance that which was in existence in the year 2016, prior to its being amended in 2017. Did you bring a copy of that with you?
Yes, I did.
And why don't you draw your attention to it, and I earlier read it into the record, but as a professional planner, tell us how you read it. I don't want you to opine as to what you thought the governing body thought, or what their intent was, but tell us what the ordinance says, in your opinion as a planner, what it means.
So the site is located in the SED zone. It permits a variety of uses, and that's under section 188-79. And the uses include a number of manufacturing uses related to finished products. And in particular, the SED zone in Howell permits the manufacturing of food products, textile products, apparel and finished products from fabric, lumber and wood products, and also metal products. And as we stated, one of the principal permitted uses in the zone at the time, before the ordinance was revised, was concrete products. And that's under section 188-79B1P of the land use ordinance. And that reads, principal uses under P, manufacturing stone, glass, clay, and concrete products. And so then after the application was submitted, the ordinance was revised, and it was revised to do two things. The first thing is that it eliminated the manufacturing of concrete products as a permitted use. Secondly, it specifically prohibited manufacturing of asphalt and concrete. So those were the two things that ordinance did. In my opinion, the manufacturing of concrete products is a distinct type of use. The ordinance doesn't indicate that manufacturing of concrete is permitted. It says the manufacturing of concrete products, and I would add emphasis to that word products. And I think there's a distinct difference between the manufacturing of concrete and also the manufacturing of concrete products. The products is similar to other uses permitted in the zone, which I just listed, which has that term product at the end. And so again, the concrete product is really a type of finished building material, and it would include things like a precast concrete slab, something for a bridge or a foundation or a wall. There's other precast forms. They use them for septic tanks, curb stops, for instance. There's some street signs, especially along the coast, where they use that concrete street sign. And in particular, pipes, stormwater and sanitary sewer pipes, which were produced on this site by Kerr prior to the owner retaining jurisdiction of the property. And then they have things like interlocking pavers and decks. So there's a number of concrete products. And in reviewing the ordinance, again, it's my opinion that the term product is really an important qualifier here, and it's part of many of the permitted uses in the ordinance. Based on the way the ordinance is written, these materials have to be manufactured products that are made from concrete, wood, leather, glass, or metal. And if you look at the other permitted uses in the SED zone, they also qualify by using the term products. So for example, based on the ordinance, you can't manufacture leather by itself, or paper, or lumber. It says that it does not say you can specifically make those items on site. You wouldn't be able to construct a paper mill, for that instance, in Howell Township, to make pulp for paper, or a lumber mill to make lumber. What you can do is you can make paper or lumber products. And under the ordinance, which, for example, if you're creating a paper product, it would be something like a paper cup, or for a lumber product, it would be something, for instance, to like make furniture. So again, by adding the term products, it seemingly lessens the intensity of the uses permitted in the zone, which in my opinion may have been the township's intention when they wrote the ordinance. So looking at manufacturing of asphalt goes beyond what would be permitted in the SED zone. It's my opinion, it appears to be the intention of the township was not to include asphalt plants as a permitted use in the SED zone, or to manufacture concrete by itself.
Is there anything in the ordinance prior to the amended ordinance in July of 2017 which makes any reference whatever to the production of or the manufacturing of asphalt?
No, it doesn't. And then,
Now, in the Township of Howell, did you have occasion to read the review letter of the zoning board planner?
yes, I did.
Now, the zoning board planner points out, in fact, that in Howell Township, pursuant to one of the ordinances which we'll get into, in 2016, which is the time frame in which we're speaking of, is that if a particular use is not listed as a permitted use, it's deemed not to be a permitted use.
That's right.
So in other words, if in fact asphalt is not mentioned in the 2016 ordinance as it stood, it is deemed to be not a permitted use.
Not a permitted use.
Right.
And in looking at her letter, she states, and this is her letter of August 18th, she states that the prior ordinance permitted the manufacturing of stone, glass, clay, and concrete products. And then she says that the zone doesn't explicitly permit manufacturing of concrete or bituminous concrete in the current or previous ordinance, thereby requiring a variance. And when she says requiring a variance, I would just add that that would be for a use variance. So for a use that's not permitted within the zone, it would be a D1 use variance. And the same would apply then to Mr. Mallon's letter as well, his amended letter, August 15th, 2017. He said that in addition, the manufacturing of concrete is also not listed as a permitted use, only concrete products, which was removed from the permitted use.
Now, the 2016 ordinance as it existed prior to its being amended in 2017 does in fact utilize the word concrete, does it not?
Yes,
Having said that, though, it limits that use to a concrete product.
that's correct.
Okay. Now, do you know whether or not there is in fact a literature which is applicable to municipalities that specifically delineates and/or differentiates the uses of, or the product of, concrete as compared to asphalt?
Yes, there's something called, it's called the NAICS, which is the North American Industrial Classification System. And that's the standard used by the federal government. And what they do is they classify all the business establishments and uses. And the purpose of the federal government doing that is that they collect and they analyze and they publish statistical data related to the business economy. And so one of the good things, especially for planners and for zoning boards, is that each and every use is first broken down by the type of sector that they're in, and it's given a 2-digit code, and then that 2-digit code then is further broken down into a 6-digit code depending on the actual type of use. And in fact, some municipalities use the NICS to reference their permitted uses in the zoning code. So let me just go into this a little bit further. So for the different sectors, and this is the 2017 NAICS, the sectors include, and the two-digit number would be number 22 for utilities, number 23 for construction, 42 for wholesale trade, 44 and 45 for retail trade, 51 for information, just to give you some examples of that. The manufacturing sector begins with numbers 31 through 33, and as you get into specific types of manufacturing plants, that number lengthens into a six-digit number. So, for instance, the ready-mix concrete manufacturing plant has a number of 327320, and a definition is provided for those particular uses, and it's under the manufacturing sector. And I bring this to the board's attention because what the NIACS classifies is that the manufacturing of concrete products is different than the manufacturing of asphalt. Manufacturing concrete products under the NAICS includes a wide variety of items within that category, and that category is called non-metallic mineral production manufacturing. And they include, like I just said, that whole list of blocks and precast poles and pipes and that type of thing. Asphalt paving mixtures and asphalt paving, on the other hand, is a completely separate category than concrete products.
Wait, I'm going to stop you. This has nothing to do with how our ordinance, this NAICS, I don't even believe it is part of our ordinance. So I would like to stick to our ordinance, if you don't mind.
I was going to say that for Cross, but I agree that I don't understand how the NAICS has to do anything with the interpretation of the zoning ordinance
The
in
board-
Howell, New Jersey.
I mean, the board, of course, will be free, as I would advise the board, to weigh all the testimony, but I would permit Mr. Gazarovski to make his case with that. It's just so that the board can listen and make that ultimate decision on it.
Thank you, Mr. Trump.
Yeah, but I just got a question to Jack. Do we use the NAICS
We do not.
as reference to our ordinances?
We do not.
Then that's why I'm kind of stopping it, Mr. Tropoli. I understand that, but that is kind of clouding the picture here because that's something we don't use as
Chair,
our
I'll
basis.
I'll defer to your ruling. Again, this is part of his case, which you're free to accept or reject.
I would like to move on without that because
that
we
was my
don't
next
use
comment.
that in our building codes.
I would only argue that it is probative because your ordinance only refers to concrete. And what I want to establish is that nationally, in accordance with national standards, there is a difference between a concrete product and an asphalt product which is manufactured with the use of bitumen, which is metallic. So the only purpose of it is to draw a clear distinction by what your ordinance
Okay,
permits.
But once again, my objection stands.
okay, noted. Move forward. Let's kind of speed through this.
I'll speed through it. So
Thank you.
if you can, give us a capsule version of the distinction made under the NAIC, the differences between concrete
Mr.
product,
Chairman, we're going
asphalt
back to
product.
the
Hey,
NAIC.
noted. I note that. Let him put that on,
Okay.
and then you can cross
Okay.
over.
You understand?
Yeah, just finish up on that.
Just finish up on that.
Yeah, and I think that just the importance here, and I'm just going to be just very brief, is that the Howell zoning ordinance is consistent with the NAICS in terms of separating out those two different land uses. So I think that neither Howell nor the NAICS treats asphalt plants the same as concrete product manufacturing, or the manufacturing of concrete as a single product. And I think that ordinance 01721 only further defines and clarifies what's permitted and not permitted in the township. And that's all I would say about that.
Mr. Butler?
Once again, my objection has to be noted for the record. There's no connection between the NAICS and Howell Township's ordinance, either past or present.
So noted.
Mr. Chairman, experts oftentimes refer to national publications and standards, so
I
that was the
understand
purpose
that,
of it.
But it's something that our professionals don't use, so I can't turn to my professional and ask them a question on the NAICS. You know, they don't use it.
Okay.
And I want to keep it to where this board understands things based on our references from our professionals.
Right. Now, Mr. Thomas, you also indicated that you reviewed the two letters of Mr. Thomas, did you not?
Oh.
Mr. Mallon.
Yes,
Now, did you also review the letter of the board planner, Ms. Apte?
yes.
We're going to call her, but can you give us the sum and substance of what she opined and whether you agree or disagree with what she opined?
I'm going to note my objection to this,
I agree, it's already been testified to.
and the
it's
letter,
already
the
been
letter
put on
speaks
the
for
record.
itself.
Okay. Let's assume now, for the sake of argument, that letter is on the record. We're going to call Ms. Apte. She'll testify as to it. Mr. Thomas can certainly opine as to whether he agrees with her or not.
Correct.
Okay. Now, you've read the letter,
I have,
and do you agree with her analysis?
I do.
Okay. Mr. Chairman, as to this, and I understand the board attempting to focus this on a particular area. So rather than going into anything further at this particular time, I have no further questions of Mr. Thomas.
Okay.
I think it's cross-examination time.
Yes, sir.
Okay,
Mr. Butler?
thank you. Good evening, Mr. Thomas. You said in the preparation for your testimony tonight, you went to my client's site? Is that correct?
I was on the road outside the client site, yes.
Did you actually go on to my client's site?
No,
Did you speak to my client?
I did not.
Okay. You also said that you reviewed the ordinance from 2016, correct? The ordinance that was in place in 2016?
Yes, yes,
And you reviewed the ordinance that was in place in or the ordinance that was adopted in 2017?
yes.
Did you review any prior versions of the ordinance?
I'm going to object to this cross-examination because it's outside the scope.
It's not outside the scope.
He's going back, he's dealing with the ordinances.
Right. I'm dealing with the fact that I'm trying to understand what your expert looked at to form his opinion.
He's not referring to the ordinances, he's referring to prior resolutions.
No, I did
No,
not. I
he said ordinance. He
I
said
think it's an area
quote-unquote
that
ordinance.
he can get into, Mr. Gazarovski, because he talked about his scope of review, and I think council, if I may, is attempting to find out what exactly he did review.
Correct. Did you review any prior versions of the ordinance?
Not any prior versions of the ordinance, I did not.
Did you review any prior history of the SED zone?
I don't know, it's really a very general question.
I know.
Once again, I'm trying to plumb to figure
I know.
out what he looked at.
You objecting or
I'm objecting.
noted?
I'm sorry, is he,
I
Mr. Thomas going to
noted
answer?
the objection. You may go.
I'm sorry, is Mr. Thomas going to answer the
Yes,
question?
please, answer the question.
Reviewed the prior resolutions,
I'm sorry.
No, not resolutions.
The prior
He asked
history
ordinance.
not
of
the
the
prior,
ordinances
not the
or
prior.
the SED zone.
No, I did not.
Okay.
So you said that you reviewed the version of the 2016 ordinance, correct?
Yes,
Where in that ordinance does it say finished?
Does it say what? I'm sorry, could you repeat the question, please?
Sure.
please.
Mr. Thomas opined for a while that ordinance 188-79 listed a number of permitted uses, and he said the words finished, and that many of the uses in there had the words finished. So what I'm trying to figure out is where in that ordinance, section B, permitted uses, is the word finished?
I said that they were products.
I agree, you said the word products a lot. You also said the word finished.
Right, well, manufacturing is, if you look in the dictionary,
What dictionary?
Let him answer the question,
it's
please,
the, it's
Mr. Chairman.
the process of converting raw materials or components into parts, into finished goods that meet a customer's expectations or specifications.
Where is that?
It was just a dictionary.
What dictionary?
I don't have it.
Oh, you're just off the top of your head.
It wasn't off the top of my head. I looked in the dictionary. I don't know which one it was.
Okay.
And
Just
I
like-
don't have that with me.
Okay. Just looking at the ordinance, where does it say, is the word finished?
It doesn't say it particularly in the permitted, in the principal uses, but
Thank you.
it's assumed that it's in,
I said,
No assumption.
there's no assumption.
Thank
I
you.
said, because what you were arguing before is that you need to take a look at the ordinance on its face. And what I just heard you say is that the ordinance on the face doesn't say the word finished. Am I correct?
it doesn't specifically say that.
There is one item on the ordinance that is a permitted use that says finished. It's number J,
Correct. One item, correct?
one item.
Does the word finish appear in letter P, manufacturing of stone, glass, clay, and concrete products?
No,
Thank you. You spoke for a while about products, and you said that you were trying to make a distinction of the fact that if it's a product, the use is less intense. Did you not say that?
yes.
Okay. What is your support behind that belief?
I think when you're actually making one of the products, and I would go to a paper mill, possibly perhaps, is to be making paper. Looking at making the actual product itself that's listed in there is more of an intense use.
And we don't need to get into the intent. Now you're getting into merits
Oh.
based
No,
on planning.
I'm asking the question because he was trying to make a distinction that if the word product is in there, it's a less intense use.
Yeah, I don't even want to go there because you're getting into the merits of why you would need a use variance, and I don't want to go there.
Okay. Did you review my client's present application before the planning board?
Yes,
And what use are they asking for?
Could object to that line of questioning, Mr. Chairman.
He
What-
said,
what-
As far as the use, I will permit that question. Just the use, nothing else. Just the use, because that's the whole basis of the ordinance.
Do you understand the question?
yeah. So what the application said, and in part, the application stated it was, and I'll quote, to remove, and this is from the application dated March 13th, 2017, to remove the existing concrete manufacturing facility and develop a bituminous concrete manufacturing facility, which will include the recycling of concrete.
so it's for a bituminous concrete manufacturing facility?
That's what it said.
And once again, just for the record, you did not review any prior versions of the ordinance regarding the SED zone?
No.
Okay. How do you interpret an ordinance?
Basically through my experience. I've written ordinances for other towns. You look for definitions, perhaps, in literature. There's a number of examples, obviously, in different towns. Use those. So basically through experience as a planner.
Okay. Legally, how do you interpret an ordinance?
I don't understand the question legally.
Is this calling for
So-
a legal
No,
opinion?
I'm calling it, as a planner, how does one look at an ordinance and interpret what's permitted or not permitted in the zone?
That's why we're here. We're going for an interpretation.
Okay, I'm asking you, how do you do that as a planner?
Sure, I'm going to object. The witness can only opine. It's this board that makes the legal decision as to what it means.
I understand, but I hear where Mr. Butler's coming from. He's wanting to know how a planner applies the ordinance. How does he come to a legal decision on the ordinance? In his, am I
Correct.
correct?
Correct.
In his opinion, how does he end up knowing the legal aspect of an ordinance? Is that correct?
Correct, I'm sorry.
Okay.
Do you understand the question?
Yeah, again, through my experience of writing ordinances, through looking at the NIICS, which is actually
Okay.
a good reference,
Okay, so
through other reference materials.
the use of your experience.
No,
That's-
it's more than that. I think I expounded upon that.
Okay.
Looking at other materials that are out there when we come up with an ordinance.
Okay. And so your opinion is that, or the sole crux of your opinion is that concrete in and of itself, or bituminous concrete, is not a product.
It's not permitted in the zone.
That's not what I asked.
Yeah, but
I asked,
I think we're getting a little off track, you know,
What?
I think that's kind of getting into why we're even here.
right, we're here to find out
But
what.
not a definition of bituminous concrete in.
Oh, no, I wasn't getting into that. I was simply asking, concrete, my question was, their argument is that concrete is not a product. Correct?
Correct.
It's not a permitted use within the zone.
That's not what I asked. I said, is concrete a product?
In accordance with the zone, is that what you're saying?
No, what I'm asking
No.
is concrete a product? It's not a trick question.
Well, it kind of is. I mean, you have to look at it within reference to what the zoning ordinance says.
Okay, underneath, in your opinion, what is a product?
We looked at concrete products. I've given
No,
you
no, 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 no.
I've
Listen-
given you
listen to-
examples.
Listen to the question I asked. What is a product?
It's a finished material.
Okay, what's your definition of a finished material?
I've read the definition of manufacturing.
Okay,
Manufacturing is the process of converting a raw material, a component, parts into a finished good that meets the customer's expectations or specification. And a finished good would be a concrete product.
okay, and why isn't concrete a finished good?
I think, again, with respect to the ordinance, I think you're taking, concrete is just a component.
I'm asking, why is concrete not a product? Underneath what you just told me is your definition of a product. Why is concrete not a product?
It's a raw material.
What's your definition of a raw material?
I don't have the definition of raw material. It's a component used to make something, a finished product.
What's a food product?
I don't have that definition.
Okay. Underneath the permitted uses in this zone, manufacturing of food products. Can I make soup in this zone?
What number are you referring to?
I'm referring to number H, B1H.
Okay.
Can I make soup?
It's a food product.
Okay. Why is soup a food product?
Because there's ingredients in soup. It's a
What's
finished
concrete?
product. It's a component of something.
Underneath the P, manufacturing of stone, glass, clay, and concrete products. Can I make Play-Doh? Can I make modeling clay?
Yes,
Why?
because clay is part of the product, of Play-Doh,
And concrete is not.
correct?
Why?
You said that concrete is part of the product.
No, what he's saying is concrete's a raw material.
You know, Mr. Chairman, respectfully, we're just beating this to death. I mean, the ordinance says what it says.
I'm simply trying to figure out what his definition of a product is and why there's a distinction between
I agree.
what
I-
cement
I'll let-
is.
you listed about 10 products, headstones, head walls, various items such as that.
Okay.
Mr. Chairman, I would.
Yes, sir.
I would respectfully request, Mr. Butler, that we move on from this. I
Yes.
think you've
Sure.
made whatever points you can,
Okay.
and obviously in your direct presentation, I'm sure that it'll be covered more fully.
Yes.
But I think the answer has been given, and we should move on.
Okay. I have no further questions of Mr. Thomas.
Okay, at this time, I'm going to ask that we take a 10-minute break here for, I got board members, including myself, that needs to go the other direction. The board's going to take a 10-minute break. We'll reconvene at 9 PM.
The zoning board will now reconvene.
Okay, I think we had left, the cross was completed.
Actually, am I permitted to ask one more question?
Yes, sir.
Okay. Mr. Thomas, you said, just going back to what you reviewed, to form your opinion, your client is Stavola Leasing LLC?
Yes?
Did you review their current application in front of the planning board?
They don't have one, I don't believe.
And if they did, it's not relevant.
It's not
to
relevant.
Council, so I would ask that you sustain my objection.
Thank you.
Thank you.
Okay.
Okay.
I have no
Mr.
further questions.
Gazarovski, thank you.
Yeah, let me, if I can, Mr. Chairman, let me just read into the record the property that is owned by Stavola Leasing, so that it's for the record. It's on the southwest corner of Route 33 and Fairfield Road. It's known as Block 168, lots 18, 19.02, 19.04, and 19.08. And I would state for the record that the applicant in this matter, Stavola Leasing, does not own or manufacture asphalt.
May I
Yes, sir.
address that? There's currently an application pending before the planning board.
Okay, I'm going to object, but Your Honor, Mr. Chairman, you've ruled on this already.
Yes.
Here's the reason I'm saying it. The applicant is Stavola Leasing LLC. The property in question is directly across the street from my client's property. It's block 184, lots 1, 1.02, 3.02, and 22.
Those aren't the lot and blocks I've just read out.
Correct. Those aren't the lots and blocks that he read out. What I'm talking about is there is a current application pending before the planning board.
I
Once
don't
again,
think it's-
I'm going to object.
But, the reason I'm saying this is there's a representation that they own property that's not across the street from my client's property. And all I'm saying is that there's an application pending before the planning board where it lists owner, Stavola Leasing LLC.
The applicant in this matter is Stavola Leasing, period.
Okay, period.
And my point is, they own property across the street, that's
Okay,
all I'm saying.
noted. Okay,
Finish. Mr. Gazarovski.
I just have a couple of follow-up questions, redirect. Mr. Thomas, you earlier read from the application made by the objector in this matter, L&L Paving. With regard to the zone in question, is a recycling facility a permitted use
I'm
in the zone?
objecting, that's not neither here nor there,
right.
redirect,
and it's not.
No.
Redirect is specifically to clean up
Things that
questions.
he
And
was
the
questioning.
ordinance speaks for itself. Now, with regard to redirect, council has questioned you repeatedly over this issue of what a product is. With regard to the earlier use, what was clearly set forth was manufacture of stone, glass, clay, and concrete products. And beneath that, it says manufacturing fabricated metal products. And above that, it says manufacturing leather products. Now, can you manufacture leather, or is that something which is naturally part of animals?
You can't manufacture leather itself, just like you can't manufacture paper or concrete.
Would you interpret leather product to mean things such as saddles or handbags or things of that nature?
Yeah, you would actually be taking leather that's already been manufactured and then making a new product out of it.
Similarly, if you were manufacturing a concrete product, that would be the things you earlier listed, things such as pipe and et cetera.
Things made out of concrete, correct.
Now, counsel, I believe, referred earlier to the use that was on this property prior to his client acquiring it.
That's right.
Do you know what was being done there?
Actually, I didn't. I object to that. I never referred to the prior use of the property.
Okay, fine. I have no further questions.
Thank you. Okay, Mr. Butler.
I'd like to call,
Oh, you,
I'd like to call as witnesses Mr. Mallon and Ms. Apte, and I'll be very, very brief with them.
okay,
Although normally it's not done, Mr. Chairman, for the purposes of the fact that he's already requested it, I have no objection because they will testify, and I expect that
I
they'll
would like to
testify
keep
on,
it based
on
on
their
their
letters.
report, their review
I shall.
letters too.
I shall.
I don't
Right,
wanna
again,
get
in a
that.
summary fashion, perhaps, Mr. Gazarovski, with great respect, because the letters are already in
I'll be very
evidence.
summary.
So, very good. So, proceed, please.
First, address my questions to Mr. Mallon. Mr. Mallon, you are in fact the zoning board engineer, are you not?
Yes, sir.
And were you earlier the author of two letters which were sent to the board, one being dated the 14th and an amended letter being the 15th?
That's correct. Those are exhibits B3 and B4.
And those are the letters which have been marked into evidence.
Yes.
Now, since that period of time, have you in any way changed your mind with regard to the opinions put forth in those letters?
No.
I have no further questions.
Okay.
Next, Ms.
Can
Apte.
I cross?
Oh, I'm sorry.
Yes,
Okay, thank you. Mr. Mallon?
Yes.
Before Mr. Gazarovski said he spoke to you in between the issuance of your August 14th and August 15th letter. Is that correct?
Would you repeat that, please?
Mr. Gazarovski earlier, he stated that he spoke to you between the issuance of your August 14th and August 15th letters,
That is correct. He called me and asked the question.
and that something changed in your letters after you two talked.
Not changed, added.
Okay, what's another definition for added? Your letter changed, did it not?
Yes, it did.
Okay, thank you.
Okay.
Mr. Mallon? Were you ever the planner for the planning, ever the engineer for the planning board?
Yes, sir.
Were you the engineer for the planning board in 1989?
Yes.
Were you the engineer for the planning board in 1989 when it issued the approval for a concrete manufacturing facility on Yellow Brick Road? The applicant was Harms.
Well, yes, I know what it was, yes.
Okay, did you issue a report on that application?
I did.
Okay. Did you say for that concrete manufacturing facility that no variances were requested and none appeared to be required?
That's correct, I did.
Okay. And that's, do you know where that property was located?
Not sure. Hold on, tell you a minute, because I have the map. Block 182, lots 6, 7, and 8.
And just for the record, I want to make sure that we're complete. I'm going to enter you wrote two, I apologize. You wrote two memorandums. I'm going to enter them into the record. Eileen, what am I up to?
Mr. Butler, can we hold off on this for a second?
Sure.
Because you're starting your testimony, this is supposed to be redirect. or
No, it's cross.
Cross-examination.
Yes, and I'm crossing Mr. Mallon on his
No,
opinion.
I know, but that's not part of your testimony yet, correct?
No, I haven't provided any testimony from any witnesses yet.
Right, that's what I'm saying, this is all new testimony.
Correct, so the questions I'm asking right now to test the veracity of Mr. Mallon's opinion in his August 14th letter.
Okay, so we're going to move right into the testimony then.
Let's get Mr. Gazarovski is still, in his
Right.
direct case, so he's called I assume he's gonna call both, board's
Right,
experts.
I would like
and-
to finish up Mr. Gazarovski
Right, and
before we
that's what
move forward.
From what I understand, that's what Mr. Butler is doing, is cross-examining Mr. Mallon, and was finished with Mr. Mallon, and Mr. Gazarovski will then move to Ms. Apte, I presume, and then there'll be cross-examination, and then I then presume he'll be completely finished.
Okay,
And-
Proceed.
and
Go
I-
ahead.
And thank you for your indulgence. Pardon me, Eileen, what exhibit am I up to?
08
Okay, and
and I guess
09.
09.
All right, I'm going to enter into the record two, sure, I'll give him his own copies. What is 08 and 09? There are two review memorandums from Mr. Mallon, one dated November 22nd, 1989, one dated September 6th, 1989, regarding a site plan in front of the planning board for Harms Lot 6, Lot 6 through 8, Block 182 on Yellowbrook Road in the SED zone.
Yeah, that's already on there, just initial and date.
And once again, Mr. Mallon, your opinion in this review letter for a concrete manufacturing plant was that no variances have been requested and none appear to be required.
That's correct, it was.
Okay.
Now, you do understand the ordinance was different?
I haven't gotten to that yet.
Well-
I'm getting to it.
Okay.
You were getting to it, okay. In 1989, what were the permitted uses in the SED zone?
I'm going to object to the question because we haven't yet established that at the time the zoning in question was for an SED zone.
Mr. Mallon, was the property in question for the Harms application in the SED zone?
Yes, it was. However, you have to understand, the ordinance book was not changed at that time. It was still called the industrial zone. But the map showed it as SED.
In 1989, it showed it as SED?
The map did. But the ordinance book did not.
And your 1989 memorandum says it's in what zone?
Well, it was labeled the SED zone, but it was, the book still had it as the industrial zone.
Okay, and what were the permitted uses in the industrial zone at
Permitted
that point?
uses, office and office buildings, warehousing, shipping and receiving, research, manufacturing, finishing and assembly of products, utilities, outside storage areas provided their location conforms to the setbacks for a principal structure, industrial operations where the manufacturing, finishing, and assembling of the principal product does not involve any change in the molecular structure of any ingredient.
And so the manufacturing of products was permitted in the industrial zone at that time?
That's correct.
No further questions.
I have a question, if I may. Looking at that letter of November 22, 1989, just so it's clear in my mind, you're saying that at that time that letter was written, the property was still in the industrial zone?
Say that again?
When you wrote this letter in November of 1989, or when the application was filed, that the property was in fact in the industrial zone?
Well, the SED and the industrial zone were one and the same.
Okay. Now, looking at the second or third paragraph of your letter, this was an application to expand a building or concrete plant to an existing concrete plant operation. Now, are you aware of when that existing concrete plant operation had been approved, and when it was approved, what the zoning was at that time?
I was not, no.
Okay, so what you were reviewing was you were reviewing an addition to an existing concrete plant operation.
That is correct.
Thank you. I have no further questions.
Mr. Mallon, if a use isn't permitted in the zone and there's an expansion of that use, where does the application go?
Well, evidently, first of all, I wasn't the zoning officer.
No, I'm asking a general question.
All right, repeat it again?
If a use is not permitted in a zone, it exists, however.
Yeah.
There's an expansion of that use. Where is that application? What board is that application?
Well, normally, if you're expanding a non-conforming use, you go to the zoning board.
Okay, where was this application?
This was in the planning board.
Thank you.
Mr. Mallon, were you aware of whether or not, in response to Mr. Butler's question, there had ever been an opinion letter or development permit issued by the zoning officer, if you're aware of it?
I don't know. I was the engineer, the zoning officer made the determination, came before the boards, and actually, at that time, I was both the planning and zoning board engineer.
Now, Mr. Butler earlier questioned you as to whether you were a planner and/or the like, but your sole function, both as to the letters you just wrote,
I never asked that
as well as
question.
back then,
I never asked that question.
I think you
Jeff,
did, were just
I didn't. I asked if he was. an
simply
engineer.
reviewing them as the engineer, nothing else. Correct?
That is correct.
Thank you.
Mr. Gazarovski?
Having said that, and just listening to cross-examination, do you still stand by your letters of the 14th and the 15th that were written with regard to this application?
I do.
Next, we have a question of Ms. Apke.
Okay.
Did I pronounce that correctly?
Yeah.
Thank you very much. We earlier referred to, and we have marked as an exhibit, a letter which you sent to the Zoning Board of Adjustment in your capacity as the zoning board planner, correct?
Yes.
And I take it that, as is Mr. Thomas, as will probably be the witness to Mr. Butler, you are in fact a licensed planner in the state of New Jersey.
Yes, I am.
And how long have you been so practicing as a planner, professional planner?
I don't think
I don't-
that's
yeah,
proper line. She's my board attorney,
Okay.
so.
Planner.
Board
We
planner.
accept her qualifications.
Yes, she's been accepted from day one, so.
I understand that. Now, having said that, prior to coming here this evening, did you have occasion to review once again the letter which you wrote in October the 18th of 2017?
Yes, I have.
And do you stand by the opinions which you gave as of that date with regard to the question concerning the interpretation of the ordinance that was in place in 2016?
Yes, I do.
Have you changed your opinion?
No.
I have no further questions.
Mr. Butler?
Sure. Ms. Apte,
Yes.
what's a concrete product?
It's a product of concrete.
What does that mean?
That means a product is defined as fabricating and assembling a material, and you end up with a product.
Okay. Underneath that definition, how is concrete not a product?
I didn't say that. I didn't say concrete is not a product.
What is a concrete product?
Concrete product is assembling and manufacturing of material to end up in a concrete product
Okay. How do you make a concrete product?
by using materials, raw materials, and ending up with a concrete product.
How do you make concrete?
I would not exactly know because I'm not an engineer, but I know there are certain raw materials used to make concrete.
If you're not an engineer
Mhm.
and you can't say what concrete is, how can you say what a concrete product is?
Well, the same way anybody can say what, a leather product is, a food product is, and things like that.
Can you make soup in this zone?
Well, manufacturing of food products is permitted, so yes.
And the manufacturing is, I'm gonna tone it down. Manufacturing is putting two things together and making something.
Yes, in layman's term.
In layman's terms, right?
Yes.
You put water, flour together, some sugar, you make a cake.
Yeah.
Okay. To make concrete, you put two raw materials together,
Gotta keep it.
mix it, you make a product?
I don't know if 2 or 3 of materials are used. I know a bunch of materials are used.
But you put a bunch of material, to make concrete, you put a bunch of materials and you make a product.
Well, you assemble, fabricate, and there is some kind of method that goes on with it, but yes, you end up with concrete.
And concrete's a product of that manufacturing.
Yes, manufacturing of concrete.
No
yes.
further questions.
I have a couple of questions. you know, we're focusing on this issue of a concrete product. And Mr. Thomas earlier gave testimony with regard to examples of a concrete product, such as a head wall, pipe, things of that nature. Now, to your knowledge, and oftentimes in manufacturing a product such as a head wall or a concrete pipe, in addition to the use of concrete, you would also introduce other items such as reinforcing rods, for example. Correct?
Could you repeat that question?
Yeah. In other words, if you're putting together, for example,
I'm going to object to this. Mr. Gazarovski, unless he's saying he's an expert at making concrete products, I don't think there's a...
this was something he went into specifically.
Who went into
Who
what
did?
specifically?
I don't think Mr. Butler went in specific.
He did. He did, and I think just limited Mr. Gazarovski, just restate the question. I think I would recommend we just permit it and then just move on from there.
Okay.
Thank you.
Mr. Thomas, in his testimony, referred to a number of what he believed to be concrete products. Do you recall that testimony?
Yes, I do.
And some of those items were things such as head walls, structural walls, concrete pipe, and things of that nature. Do you recall that testimony?
Yes, I do.
Okay. Now, they are not just simply raw concrete, are they?
No, the concrete products.
It's a concrete product. And oftentimes in producing that product, such as a head wall, in addition to just the raw concrete, you would also introduce things such as reinforcing rods and the
Once
like.
again, we're going...
If you don't
Might
know.
not
you
know.
can-
I
She's
don't
not an
know
engineer.
exactly how concrete pipes are made, but yeah, it would include a couple of
Well-
materials.
What then do you regard as being a concrete product?
Again, going back to it's using materials that are used for making concrete and ending up with concrete products.
Okay. Such as putting it into a form and creating something.
Yes.
Thank you.
Once again,
Yes.
when you're making concrete, you add things together and you come up with a product.
When you're making concrete?
Yes.
Yes.
Take raw materials, put them together, you come up with a product.
With concrete or concrete product?
Concrete, when you're making concrete, you add materials together, raw materials, and you wind up with a product.
With a concrete product, yes.
Correct. Have you ever made concrete pipe?
No.
Okay.
Let's,
I have nothing further.
okay, thank you.
Ms. Apte, in your letter dated August 18, 2017, at the top of the second page, you state, "The zone does not explicitly permit manufacturing of concrete or bituminous concrete in current or previous ordinance, thereby requiring a variance." Do you still stand by that opinion?
Yes, I do.
Thank you.
I'm not going to ask the same questions that I've asked now 3
Okay.
times, so.
Mr. Gazarovski, does that conclude your presentation?
Yes, it does.
Okay.
Okay. If you could just indulge me for 1 minute while I get my...
Yes, sir.
Just so has the board made a decision on whether or not they would stay to 11?
Yes, we have.
Okay. Just because I do think we'll be able to reach that second application. And I
Okay.
would like, if that would be, Mr. Schneider, would you come up, please? Yes.
Okay. Yes, sir. Mr. Butler, can
Yep.
we swear your,
Yes, I'm just sorry, just moving things around, I apologize.
okay,
Tonight, my first witness is going to be Charles Sanford. If you want to swear him in.
Yes. Sir, raise your right hand. You swear the testimony you give this evening will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Yes, and your name again?
Charles Sanford.
And spell your last name.
S-A-N-F-O-R-D.
And, Mr. Butler, see a planner or a
He,
witnesses expertise?
well, I'm going to qualify him. He is an engineer.
he'll be testifying as an engineer?
Yes.
Okay. Can we qualify?
Sure. Mr. Sanford, can you please give the board your education, the company you work for, what you do for that company?
Sure. My bachelor's is in civil engineering from Auburn, where I focused on structural and material engineering. From there, I went on and got a master's in chemical engineering, where I focused in the environmental side of it. Did a lot of work with pervious materials, pervious concretes. Particularly wrote my thesis on the clogging mechanisms in pervious concrete. And now I work with Aztec. We manufacture asphalt plant facilities, and what I do with them is I travel around the world to different countries and modify our asphalt plants to fit the needs of the different countries.
Okay. Mr. Gazarovski, any objections?
I do. If he's going to testify as a person who manufactures asphalt plants,
We're not going there.
right, that's not in the ordinance.
He's just qualifying.
Okay,
Yeah, he's being offered as an expert in the manufacturing of bituminous concrete.
well, that's
There
asphalt.
again, I understand.
And yeah, I'm sorry.
Objection noted, and do you object to his qualifications, though? That's what I'm asking.
I object to his testimony. He's not being called as a witness to testify with regard to concrete. He's being called as a witness to testify as to asphalt, and there's nothing in this ordinance that we're challenging that
Okay.
refers to asphalt.
He's being called as an expert for the manufacturing of bituminous concrete.
Okay, we're not here to discuss bituminous concrete at this point. We're here to limit what the ordinance permits in that zone. Is if you should be at this board, or if you should be
Correct.
at the planning board, this board for variance, planning board for approvals.
Correct.
So, right now, if we get into asphalt testimony, we're getting into the merits of the asphalt plant.
Well, we're not,
I don't want to go there.
okay.
If he can testify to the ordinances, the existing ordinances, before and after the change, then if he's a witness for that, then we'll permit it.
Okay, he's being offered as a witness. There's testimony as to what is a concrete product.
Okay, if that,
And,
so
and
far,
what he's testifying to is what is a concrete product.
okay. Do you object to that?
If he's going to testify as to what a concrete product is, I'm not going to object to, but if he's
Okay.
going to testify as to
I will,
bituminous concrete or asphalt being a product of concrete, I think it's not what we're here for.
I'm going to allow it. You can move forward, Mr. Butler.
Thank you. Mr. Sanford, you said that you, right now you are employed by Aztec,
That's correct.
and your functions there are to travel around to the various sites and make engineering changes to a bituminous concrete plant in order to,
Mr. Butler, let's stick to concrete products. Strictly
Okay.
concrete products, please.
okay.
That's what I just have one question. What is a concrete product?
That's, yeah.
Let's
What-
ask
what
that.
is a concrete
Let me throw it out
product?
there.
Okay.
In your
Mr.
opinion, what
Sanford.
is a concrete product?
So a concrete product is when you mix aggregate with some kind of binder. And that binder can be a Portland cement, or in this case, it can be an asphalt or a bitumen.
I'm going to object to this line of testimony. There's nothing in your ordinance which refers to asphalt.
No,
the question-
Mr. Gazarovski, he is testifying to what a concrete product is,
Con-
in his opinion.
Concrete can be both Portland cement or asphalt. That is the binding material in a concrete.
Okay.
Okay.
And how is a concrete product produced?
Whether it be Portland cement or asphaltic cement, they, you mix the aggregates with the liquid. And in an asphaltic concrete, it would be heated bitumen, and in a Portland cement, it would be water and Portland cement.
Okay. No further questions.
Mr. Gazarovski, any cross?
Is it Sanford? I'm sorry.
Sanford.
Thank you. Prior to coming here this evening, did you review the zoning ordinance of the Township of Howell?
I did not.
Pardon me?
I did not know.
Did not. I would move to have all of his testimony stricken.
And I object. Mr.
I
Sanford's not
agree.
up here for an interpretation of the
He's
ordinance.
not here. He's just putting on the record what his opinion is, what a concrete product is.
I
That's it.
agree. I don't think I think the board can weigh the testimony, but to have it stricken, I think is a draconian measure that, I don't think it's appropriate. He was sworn in
agree.
as an expert, accepted as an expert. The board's free to accept or reject what testimony there is, and we'll leave it at that. Thank you.
Thank you.
I have no further questions.
I'm going to move on to my next witness.
I have no further questions. I may have rebuttal, but I have no further questions. of this
Okay.
witness.
Mr. Tropoli, want to swear?
Yes. Christine Ann Nazaro, Nazzaro, Cofone, C-O, F as in Frank, O-N-E. Business address is 125 Half Mile Road, Suite 200, Red Bank, New Jersey, 07701.
Ms. Cofone, could you please give the board some details on your history, your qualifications as a planner?
Yes.
She's testifying as a planner?
Yes,
sir.
you're testifying
Thank
as
you.
a planner.
I have testified here before the Zoning Board of Adjustment, as well as about 380 other planning and zoning boards throughout the state of New Jersey. I've been practicing for about 22 years as a consultant. The lion's share of my practice has been appearing before planning and zoning boards throughout the state. My firm is also the appointed planner for the Casino Redevelopment Authority in Atlantic City. And we do have some municipal work, not a ton of it. We do honestly mostly developer work and applicant work before boards. I am an adjunct land use instructor for the Rutgers Center for Government Services, where I teach planning and zoning courses. I am also an adjunct instructor at the Monmouth University, where I teach a special topics and real estate courses. I have a master's degree in city and regional planning. My license is current, and like I said, I've been practicing for over two decades.
Your education?
I have a master's degree in city and regional planning from Rutgers University and an undergraduate degree in political science and public administration.
Thank you.
You're welcome.
Mr.
I
Gazarovski,
have no
any
questions.
objection? Okay.
No objections.
We accept your qualifications.
Thank you, Chairman.
All right, Ms. Cofone. When you are looking at an ordinance, can you tell me how you would interpret an ordinance?
Sure. The first thing we would do to determine if a use was permitted is we would look at the list of permitted uses in the zone to see what's permitted by right, permitted accessory, permitted conditionally. Sometimes it's listed in the schedule, sometimes it's listed just written out with a numerical listing of uses. So that would be where we would start. And sometimes the way those uses are interpreted requires that we look at the definition section of the ordinance, because what I may consider to be a long-term care facility may not be how Howell defines it. So after looking at the list of permitted uses, we go to the definitions, because you can get a lot of great information there. Once that's done, if we're comfortable, we can stop there. Or what we do is we look at how has the board interpreted other similar applications? And then we like to read the resolution of approval, because a lot of time in the findings of facts and the description of the application, if we have to go that far, we find some more detail about the use and how it was handled. Was it heard at the planning board or the zoning board of adjustment? Those are the type of things that go into determining the permissibility of a use.
And what are the permitted uses in the SED zone?
The SED zone permits offices, financial institutions, medical centers, warehousing and distribution, assembly and packaging, utility uses, agricultural, forestry, and agricultural services, manufacturing food and kindred products, manufacturing textile products, manufacturing apparel and similar finished products made from fabrics, manufacturing lumber and wood products, manufacturing furniture and fixtures, manufacturing paper and allied products. I can continue reading them, there's only a few more. Manufacturing printing and publishing, manufacturing leather products, manufacturing stone, glass, clay, and concrete products, manufacturing fabricated metal products, manufacturing electronic and electrical equipment, manufacturing photographic equipment, medical, optical goods, watches, clocks, and then construction, multi-purpose recreation and sports complex, and solar energy generation facilities. And that would be the list of permitted uses in the SED district prior to the July 2017 ordinance striking concrete products from the.
Thank you for clarifying. That was going to be my follow-up. So are concrete products, the manufacture of concrete products permitted in the zone?
They were, yes, prior to.
Sorry, back in
yes.
2016.
Back in 2016, yes, they were absolutely permitted.
And is there a definition for concrete products in the zoning ordinance?
There is not a definition for concrete products, and there is also not a definition for manufacturing. So when that is the case, as planners, and the dictionary is always a good guide, if there's not a definition in the ordinance, you can of course go there. As a practicing planner for over 2 decades, my personal choice to go to is the complete illustrated book of development definitions by Harvey Moskowitz and Carl Lindblom. That is, in my opinion, a pervasive, well-accepted manual for looking at definitions when one doesn't exist in the code. Certainly preferable to, say, Wikipedia or a dictionary. And also, as an adjunct land use instructor for the Rutgers Center for Government Services, this is one of the textbooks that we use in our class of training, planning, and zoning board
I'm
members.
going to interrupt you real quick. Mr. Mallon, are you familiar with this?
I am, Mr.
Do
Chairman.
you use that in
Yes.
your basis?
I do.
Okay.
Can you repeat that question, Mr. Chairman?
What is
The
for,
question of the planner, did you use that
does she
basis
use?
for her
the-
letter?
Yes.
No.
No, I
No,
didn't ask that
no, he didn't
question.
ask that
I didn't ask that question. I just want to know if she was familiar with what was placed on the record, and our planner said yes.
Right.
And she does use that.
If Mr. Butler's going to refer to Mr. Moskowitz's, may I have a copy of whatever you're referring to, so I can see it?
I can get you a copy, sure.
No, whatever she's testifying to now.
I
have a copy.
can hand it over to you.
Would you please? Yes.
Well, not right now, but once
Okay,
she's done
I understand that.
testifying, I can hand it over.
Under cross.
Certainly. So in that book, which again, in my opinion, I've been practicing for over 20 years, is a well-regarded and pervasive source for definitions. The definition of manufacturing reads, establishments engaged in the mechanical or chemical transformation of materials or substances into new products, including the assembling of component parts, the creation of products, and the blending of materials such as oils, plastics, resins, or liquors. Comment. The term manufacturing covers all mechanical or chemical transformations, whether the new products are finished or semi-finished, as raw material in some other process. Manufacturing production usually is carried on for the wholesale market rather than for the retail trade, although retail sale to the ultimate consumer is becoming more prevalent. Processing on farms is not usually classified as manufacturing if the raw material is grown on the farm. The manufacturing is accessory to the primary use of farming. And then there's a legal annotation that reads further. The rule defines manufacturing to include every operation from the beginning of production until the product is completed and packaged for sale. So from a planning point of view, I see no reason to opine that the concrete manufacturing would not be a permissible use here.
Okay, so you said that you look to the definitions. Do you look anywhere else when you're interpreting a zoning ordinance?
I did, and I looked back at the 1989 application that was referred to earlier, where the review letter from Mr. Mallon was read into the record, when there was an application by Durant Harms Construction. My review of the resolution governing that,
I'm going to object to this line of question until we first produce the application that she's referring to.
And for the record, that application has been entered into the record as 04.
Have a copy of it, please?
The resolution?
No, I want the application, not the resolution.
She's
The
testifying to the
application.
resolution.
Pardon me?
She's testifying to the
She
resolution.
referred to the application in her testimony.
well, I'm going to read from the resolution.
I know what the resolution says. I want to see the application.
Oh, okay, but we're testifying with the resolution.
Noted.
Thank
There
you.
are some very relevant portions, and they're not very long. They're on page 3 of the resolution dated December 21st, 1989. This is from an application in the SED zone on Yellow Brick Road from 1989. On page 3 of that resolution, the second whereas reads, applicant intends to construct a 12,000 square foot building to house a concrete plant and to construct site improvements related thereto. The roadway shall not be a public street. The premises, this is number 3, also on page 3 of that resolution. The premises are located in the SED zoning district as defined in the Howell Township Land Use Ordinance, and the proposed use is permitted therein. So in the whereas section of that resolution, which was dealing applicant intends to construct a 12,000 square foot building to house a concrete plant and to construct site improvements related thereto. The roadway shall not be a public street. The next statement in that resolution goes on to find specifically that the premises are located in the SED zoning district and defined in the Howell Township Land Use Ordinance, and the proposed use is permitted therein. And this was a planning board application. Now, in addition to reviewing this, I certainly did review the resolutions of Anchor Concrete and Kerr Concrete Pipe. So clearly, in those resolutions, there was a product. But in the harms resolution, to my knowledge and to my review, there didn't seem to be a product. Because in my opinion, as a professional planner, and the way this board has interpreted it, and the way the ordinance is structured, and the way manufacturing is generally accepted in the planning industry, and as an undefined term in the Howell ordinance, I see no other way to interpret it other than that it is a permitted principal use. So to go one step further, you would have to conclude for it not to be a permitted use that I could take my concrete and form it into some type of widget, and that's okay. But I left it unformed, that's a no-go. We can't do that. That's not permitted. And from a planning point of view, to come to the conclusion that the unformed concrete is somehow less intense, to me is a very peculiar conclusion. Because you would have to get that concrete pipe, that Jersey barrier, that outfall structure, whatever you were forming it into, you would have to get it off your site somehow, which is going to require some level of trucking, pallets, and things. So from a planning point of view, I certainly cannot conclude that the unformed concrete is a number one, it's not permitted in the zone, and 2, is more intensive than forming it into something.
Don't go to the intent. I don't want to go there.
Well, we're going to what the ordinance contemplates and what the ordinance would allow. So for the board to find that the formed portion would be allowed, but the unformed portion is not allowed, to me, is a very peculiar conclusion to ask this board to conclude. Because that's what you're being asked to conclude. You're being asked to interpret your ordinance such that concrete, which is the mixing of certain materials, that is not permissible. But if you were to mix that concrete and form it into tiny little widgets, tiny little forms of planners, then you could sell those, but you couldn't sell the concrete. I just can't get there from a planning point of view, so.
Okay. Do you have anything further to add?
I really don't. This is a very simple application. It's not like our usual testimony that's very, I mean, in my opinion, the testimony here is very narrow. Is
Right.
how do you interpret that one line of the ordinance which reads, manufacturing stone, glass, clay, and concrete products? Quite honestly, what was done in July of 18 to strike that from the ordinance is irrelevant. Our application was filed in 2016. So what the township committee has done subsequent to that, in my opinion, also has no place in this discussion. You're not interpreting the subsequent actions of the township committee. And quite honestly, if it wasn't permitted at the time, then why did the township committee have to take it out as a permitted use if it wasn't permitted in the first place? So I think that that has no, I understand that they took it out. I certainly reviewed that ordinance, but to me, that's not what's before the board tonight. What's before the board tonight is how you interpret concrete manufacturing. And I have nothing else further to add.
Thank you.
You're welcome.
Mr. Gazarovski?
That concludes your testimony?
Yes, mine.
Okay. I have several questions. May I see that copy, please, of Mr. Moskowitz's treatise? Thank you. May I just take a minute to read this, please?
Yes, sir. Mr. Butler, do you have any further witnesses?
I do not, Mr. Chairman.
Okay. About how much longer do you have?
This is my last witness,
Okay.
so cross-examination and any rebuttal if need
Okay.
be.
Sir? I thought you said something.
Oh, no, I was just looking at schedules.
Okay.
I want my book back.
Ms. Capone, if you prefer Ms. Capone or Ms. Zarro, I'm sorry. I want a question from this, if you don't mind.
Oh, yeah, that's
Okay.
I want it back, though. I don't write it.
Prior to coming here today, did you have occasion to review the two review letters of Mr. Mallon as well as the review letter of the planner?
Yes, I did.
Okay. Now, let's just first take a quick look at Mr. Mallon's review letter. Do you agree with Mr. Mallon's comment in those letters that the manufacturing of hot mix asphalt or the manufacturing of concrete is not listed as a principal permitted use or a conditional use in the SED zone, either previously or under the current ordinance, therefore a variance is required? Do you agree with him that a manufacturing of hot mix asphalt is not listed as a permitted use?
I'm going to object to the question.
I noted, but I kind of
That's okay.
agree. He's just asking,
No, yeah.
you know, he's
She's
just asking
testifying
if
as
she,
an expert. I mean, and she's contradicting the, allegedly, your expert's reports. And I'm asking you whether she agrees or disagrees with that comment.
that's why I want,
Yeah,
you can
my
answer that
objection,
question.
You noted my objection, it's fine.
Well, it's a fair question. I think it should be
yes,
presented. Thank you.
if she agrees with this.
You understand the question?
I do. Just to understand, which letter are you referring to? The August 14th one or the August 14th
Let's go
amended to August
Let's go first
15th?
to the August 15th one.
Okay. So to understand your
Can you-
question.
Wait one
Can
second,
you
please.
take that off the,
Sure.
Okay, this letter is dated August the 14th, and I think this was marked P3.
B as in boy.
B as in boy, B3. And I'll just read to you from the sheet 2. It says, manufacturing of hot mix asphalt is not listed as a principal permitted use or conditional use in the SED zone, either previously or under the current ordinance. Therefore, a variance is required. I'm not going to ask you about his opinion stating a variance is required, but my question is, when he refers to manufacturing of hot mix asphalt, he says it's not listed as a principal permitted use. Do you agree with that statement?
I don't agree with that statement
Okay.
because the ordinance reads that concrete products are a permitted use. The ordinance also doesn't say that Lilly Pulitzer dresses are permitted, but it certainly does allow for apparel and similar finished products.
Yeah, I'm
So
not-
I just need to answer the question, Mr. Gazarovski.
Go ahead.
So, for the board's edification, the ordinance doesn't read that Lilly Pulitzer dresses, you could manufacture them here, but based on the structure of the permitted use list, I certainly think that you could. So, because it doesn't list manufacturing of hot mix asphalt, does not, and I cannot agree that it is also not a permitted use.
I'm not asking you whether you agree or not. He states that it's not
No,
listed
that-
as
I
a...
object. You
Yes.
asked if she did
She
agree.
didn't.
That
Asked
was
and
the
answered.
question that you asked.
My question is, he says that
Once
it's
again,
not...
It's
he-
already
he
asked,
asked
Mr.
that- he asked that
Gazarovski.
question.
Not been answered. He states that
That,
it's
once
not...
again, he asked, that
May I
question's been
finish,
answered.
please?
No, the chairman said it's been answered.
One at a time. Re-ask your question,
Thank you.
and we'll decide if it's been
Thank you.
answered.
Mr. Mallon states that the manufacturing of hot mix asphalt is not listed as a principal permitted use. Not listed as a principal permitted use. Do you agree or disagree with that statement?
I disagree with that statement. I think it is a
Okay.
principal permitted
Okay.
use, just
Now-
as Lilly Pulitzer dresses or anything else that would be
Agree.
manufactured.
Answered.
Okay, can you show me in the ordinance, which you say you've reviewed, can you show
once
me
again,
in the
we're
ordinance
going-
with the words?
We're going again.
No, you know, this is cross-examination.
Just ask your question.
Yeah, can you show me in the ordinance, if you don't agree with him, where it says manufacturing of hot mix asphalt is permitted?
Well, it says manufacturing of stone, glass, clay, and concrete products. Again, the example was raised before, and your planner agreed that you could make soup in this district. Soup was permissible. When I read Ms. Apte's August 18th, 2017 review letter, it lists many permitted uses, none of which read soup, but yet she opined earlier this evening that soup was a permitted use. The production or the manufacturing of soup would in fact be a permitted use. So because this list does not specifically read manufacturing of hot mixed asphalt, is in no way, in my planning opinion, demonstrative that it's
Well,
not permitted in the zone.
That's your opinion, it's not a factual predicate.
Once again, he asked her
It-
opinion.
You asked her opinion.
Now, similarly, with the second letter, which is the amended letter dated August the 15th, he states, in addition, the manufacturing of concrete is also not listed as a permitted use. Do you agree or disagree with his statement that manufacturing of concrete is not listed as a permitted use?
I think you need to ask that whole, it's kind of taking that out of
I
context.
won't take it out of context. The line reads, in addition, the manufacturing of concrete is also not listed as a permitted use. Only concrete products, which was removed from the permitted use. So my question is, do you agree or disagree with Mr. Mallon's statement that manufacturing of concrete is also not listed as a permitted use?
I do not agree with Mr. Mallon.
Okay. Can you show me in the ordinance where it is listed as a permitted use?
It reads manufacturing stone, glass, clay, and concrete products.
Now, Mr. Mallon makes a distinction, does he not, between manufacturing of concrete and acknowledges that concrete products was in fact permitted.
I think it's already been answered.
Yeah.
Let's go to the letter of Ms. Apte, which is dated August the 18th of 2017. I trust that before you came here today, you read that letter.
You are correct.
Pardon me?
You are correct.
Thank you. Now, on page 3 of that letter, Ms. Apte makes the following statement. As per section 188-50, no land, lot or premises, and no building or structure shall be used for any purpose other than those permitted by Articles Roman numeral 8 through Roman numeral 11 for the zone which is located. The prior ordinance permitted manufacturing of stone, glass, clay, and concrete products. the zone does not explicitly permit manufacturing of concrete or bituminous concrete in current or previous ordinance, thereby requiring a variance. Now, first, do you agree or disagree with Ms. Apke's statement that, quote, "The zone does not explicitly permit manufacturing of concrete or bituminous concrete in current or previous ordinance, comma, thereby requiring a variance"?
I do not agree with Ms. Apte.
Okay. Now, if you don't agree with that, can you show me anywhere in the ordinance that was in place in 2016 where the manufacturing of an asphalt product was permitted?
That wasn't what was in Ms. Apte's letter.
No, it's not.
No more, Mr. Gazarovski, than I can point to you in the ordinance where it says manufacturing of soup is permitted, but she's already opined
talking
earlier
about
this
soup here.
evening.
This is an
But she's
example.
already opined earlier this evening that
Okay.
that would be permissible in the SED
Questions
district.
We're not
answered.
talking about soup here. And by the way, Ms. Apke says and uses the words bituminous concrete, which is the same as asphalt.
She already answered that. She didn't agree with that.
She doesn't agree
Let's
with it.
move forward.
Okay. Well, do you agree with her statement that as per the ordinance 18-50, that it has to be explicitly set forth as a permitted use?
Absolutely, well, I agree that it reads that here, that language reads here, but I don't think that it absolutely has to be set forth as a permitted
Okay, now
use. And apparently either does she, because she said manufacturing of soup would
Okay.
be permitted.
I'm sorry. Now, prior to coming here today, did you read section 188-50?
Just as it's recited in her letter.
I'm sorry?
Just as it's recited in Ms. Apte's August 18th letter.
Okay. You read what she refers to in her letter and nothing else.
Nothing else.
Now, let me just take a quick look at Moskowitz. And I know that, did you read this more than once? Are you familiar with it? And I don't want to test your memory.
When you say this, what are you speaking of?
I'm speaking of Mr. Moskowitz's definitions of manufacturing.
I'm fairly familiar with it.
Okay. Now, did you also note in here the legal definition where he refers to a case and says the rule defines manufacturing to include every operation from the beginning of production until the product is completed and packaged for sale. Do you agree with that?
I think that that's a legal annotation.
I know what it is, but do you agree with that quote from Moskowitz?
That's my recollection of how it reads in the book.
Okay, fine. And that ties in with what the Howell ordinance says when it refers to a sand, a glass, a clay, or a concrete product, the finished product.
Is that a question? Or is that
Yeah,
a
it is.
statement?
No, I need to have my book back to answer that,
I'm sorry?
actually. I need to have my book back to answer that, because I absolutely do not agree, because that legal annotation specifically reads to include the
Can
rule
you
defi- Can I answer the question? The rule defines manufacturing to include every operation from the beginning of production until the product is completed. So clearly, it contemplates that even the unfinished product is still manufacturing.
Let me just, this just simply manufacturing, doesn't it? Huh? Now, and looking at the ordinance, may I have that back, please? Thank you very much. Now, in the ordinance in question in 2016, does it list as a permitted use the simple generic term manufacturing?
It does not.
Matter of fact, when it talks in terms of manufacturing, it refers to specific forms or types of manufacturing, correct?
Sometimes finished, sometimes unfinished. There's only one instance where it references, I believe, the word finished products.
Well, in number H, it says manufacturing food or kindred products. Number I, it says manufacturing textile products. Number
Right.
J, manufacturing apparel and similar finished products.
Right, so clearly, because it doesn't always use the language finished, it doesn't always intend for the manufactured
but
products to be finished.
Now, however number there are more than one half of them that refer to a product, do they not? Leather products, clay products, fabricated metal products, they're referring to products.
They're referring to products, they're referring to equipment, they're referring to kindred products, whatever that means. They're referring to textile products, they're referring to, many different things. Wood products, furniture, lumber, apparel, lots of different things.
Now, you made reference to the use of the property, saying, I think you said there was relatively little difference between selling I think you used the word widgets or whatever it may be, and manufacturing and just simply selling concrete. Now, you're not a traffic expert or traffic
I don't
consultant, are you?
think that was testified to.
No, it's not a proper question.
Well, let me ask you this question. Do you think there's a difference in intensity of use between manufacturing
No,
concrete?
we don't want to go to the intensity, Mr.
Well, but we're going to
Gazarovski.
this, what your ordinance says.
Not, I know, but you're getting into
But
a
I don't want
narrative
to
case.
I don't want to get into, this was something which was opened up by counsel for the objector. I believe she referred to the fact that, she said it was peculiar and she said the word peculiar, that you would allow products to be sold, but not the concrete to be sold. Well, there's a big difference between the two of them.
Okay, I'll allow the, ask a question.
Do you understand what the question was?
You understand the
I think that was
question?
a statement, that wasn't a
I-
question.
Are you saying that the operation of manufacturing and just simply selling raw concrete, as opposed to selling a product is synonymous, that the truck traffic is the same, the intensity
Well,
of
once
the
again,
use
we're
is
go-
She
we're go-
did
we're going
testify
far
to that.
afield.
She testified to that.
So can she answer the question?
Can you repeat the question?
What's the question?
The question
Right, what's
is,
your question?
I understand the question. The question is the sale of a finished product, a product which would be a concrete product, such as a head wall, a
Well,
concrete pipe.
he's testifying again as to what a finished product is.
Is she testifying that the intensity of truck traffic or activity?
We're not getting into that.
Is that
I
done?
don't even want to go there. You're getting into the merits of the application.
She got into it.
She was using, okay, just to answer the question, do you believe that it intensifies or it's the same?
I think that if you were to have a finished product, it could potentially be more intensive than just having the unfinished product.
Okay.
That was my direct
That answer your
testimony.
question?
I guess it does.
Okay.
Just a couple more follow-up questions. And I know that, well, this is really kind of a slippery slope because she's being called to testify with regard to an ephemeral use. We don't know exactly what it is. But let me ask you this. You referred to the resolution that was passed concerning, I guess, the harms application, correct?
Yes,
Do you have a copy of the application?
I do not.
Okay, now, the resolution itself refers to the fact that the use being sought there was with reference to an existing concrete manufacturing plant. Did you ever look at or get a copy of the original application for this concrete manufacturing plant or the resolution that would have been passed concerning that?
I'm sorry, can you repeat that?
Sure. Let me just look at the resolution for a second. Here's the resolution.
Yes, sir.
I just want to point out, and again, I know council, both are diligently working towards a conclusion, but we do have another application, and it doesn't seem that we're getting close to being finished. And again, we had carried the other application, I think, 3 times
Yes.
so far.
I do want to get testimony on the record for that.
So,
If-
I just want to put it out to the board whether or not they wish to break at this point. I realize it may be a little difficult during cross-examination, but there's probably going to be rebuttal, there's going to be closing arguments. It's going to take, I think, a fairly long period of time for that to happen. And again, I just want the board to decide whether or not they wish to continue with this application. for whatever long it may take, or break it now, and it can conclude at another occasion, so that we can get some testimony on the record on the other
Can I
applications.
make a suggestion, maybe to get through the cross-examination, so we're not breaking at an odd time where the board's gonna have to try to remember what.
How much more cross-examination?
Not much at all.
Okay,
I would suggest that Mr. Gazarovski, that you conclude cross, and then that I still recommend that we break it in all fairness to Mr. Schneider and his applicant. Again,
Yes.
that's for your consideration, but just in terms of scheduling.
is that okay with the board? Okay. Mr. Gazarovski, can you,
I'm almost through.
okay.
You're familiar with the letter of Mr. Mallon, which council submitted dated November 22, 1989, are you not?
I am.
Now, in the third paragraph of that letter, Mr. Mallon stated, to summarize, this application proposes to add a 12,000 square foot storage building concrete plant to its existing concrete plant operation. Now, there's nothing in that resolution, which approved the use of a concrete manufacturing plant, other than to allow it to be added onto, correct?
The resolution specifically reads that the applicant
I'm not referring
intends
to
to.
the resolution. I'm
Yes, you
referring
just
to his
asked me about the
letter.
resolution.
Was the resolution?
I'm asking him with regard to his letter.
Was that the professional letter or the resolution?
This is the professional letter, and I identified it as being dated November 22,
Just for clarity,
1989.
he then asked about the resolution.
Okay.
I'm cross-examining her with regard to the letter. This is what he says.
Once again, he said, I was just making sure the question's clear.
Well, okay, let me make it very clear. I'm referring to a letter which is dated November 22, 1989. In that letter, Mr. Mallon states, to summarize, this application proposes to add a 12,000 square foot storage building / concrete plant to the existing concrete plant operation.
Right, and let me make it clear that if
Pardon?
that was a non-permitted use in the zone, the zoning board of adjustment would have had jurisdiction. So
Well-
whether the concrete plant was existing or proposed is irrelevant.
Okay,
Because if
well-
it was not a permitted use in the SED zone, then it wouldn't have been a planning board resolution,
Okay.
which it was.
Fine. Did you ever see the original resolution
He already asked that question.
approving the initial or first concrete plant? Did you ever see that resolution?
Mr. Gazarovski, I don't think she would need to see that resolution because this is a resolution that would have been at the zoning board if it required, she answered the question.
Well, having said that, Mr. Chairman, if in fact the plant was approved at a time when the use in question was a permitted use, such as in the industrial zone, it would come back to the planning board.
It did come back to the planning board.
Well, that may very well mean that when it was first approved, it was a permitted use, but it simply no longer is.
And we'll go to the zoning.
Okay.
Then it would go to the zoning board for an expansion of a non-conforming use.
Exactly.
It wouldn't go back to the planning board.
Sure it would. Now, let's go a little bit further. You've never seen either the original application when the plant was first approved or this
I'm gonna object to
application.
this
It's
whole
been
line, this
answered.
whole line of
That's been
questioning.
answered.
It's been answered. Asked and answered.
I'm going to ask it again.
It's been answered. She said no,
She
she
has
hasn't.
not seen it.
She said she has not seen it.
Okay.
Any further questions?
Just one perhaps last question. And I don't wish this to be repetitive, but other than this resolution, which you've testified as to, and other than the letter of Mr. Mallon, which is dated 1989, did you make any attempt to look at or review any other portion of that file dealing with that 1989 resolution?
Once again, asked and answered.
It's been answered.
No.
That question is not the answer.
It's on the record.
It's on the
You asked
record.
it already, 4 times.
I have no further questions.
Okay.
Mr. Chair.
Okay.
again, without prejudice to anyone here, I think what we may need to do just very quickly is establish a date. We had initially canceled our November 27th meeting so that we could have a rules committee. However, we have December 4th available that we could do the rules committee meeting then so that we can
Correct.
finish this application and very likely continue with the other application, which we will start tonight.
Right.
Assuming that everyone can make it on the 27th of November.
Yes.
Mr. Gazarovski?
27th of November?
Yes, sir.
I can make that.
Okay. And this
And-
way, we can carry this application. Council can prepare their closing arguments if there's rebuttal,
Right.
any omitted questions, whatever.
Okay,
I think it'll be cleaner that way.
Yeah, I agree. Can I just note for the
Okay,
record?
case number
Hang on,
BA 17.
Can I just note,
I'm sorry, Mr. Chair, I think council wanted to address this.
I apologize. Can I just note for the record, both Mr. Gazarovski and I said that we are available on the 27th.
Correct.
Very good.
Thank you.
Thank you, sir.
Okay, case number BA 17-13, Stavola Leasing LLC will be carried to November 27th, 7:30, with no further notice.
Thank you very much for your indulgence.
Thank you. Thank you, Mr. Gazarovski. Okay,
I won't, I'm sorry. Oh, there you go.
I'm gonna go ahead and are you ready?
Give me 2 seconds for Mr. Butler to clear out.
How long is it gonna take you to set up?
I've already set up, I just have to sit down.
Okay.
Check a minute.
Taking 5 minutes before the new application starts, or
Sir?
are you taking a few minutes before the new application starts?
No, sir, I wasn't, because I want to get some testimony out.
What's that?
Okay, I'm gonna go ahead and read in.
You can leave it with that.
Do you guys, do you need this?
Case number BA 17-09, NAI Hanson as agent for Fairfield Industrial Park, LLC. This is a use variance. Description, application, NAI Hanson Management as agent for Fairfield Industrial Park, LLC as applicant, and Fairfield Industrial Park, LLC as owner seeking a use variance to allow existing tenants the ability to continue to operate on premises known as Block 168, Lot 8, 8.02, 912-922 Highway 33. This application was scheduled to be heard September 25th, 2017, when it was carried to October 2nd, 2017, with no further notice. October 2nd, 2017, the application was carried to November 13th, 2017, with no further notice. Expiration date, December 14th, 2017. Mr. Snyder.
Thank you. Good evening. My name is Paul Schneider. I'm an attorney at Giordano, Harron & Ciesla, and I'm here this evening on behalf of NAI Hanson Management as agent for Fairfield Industrial Park, LLC. The Fairfield Industrial Park, or Fairfield Business Park, is approximately 164,000 square feet in 9 buildings in the township's SED zone. It's long been a presence here in Howell Township. The applicant, however, is new to the scene. Fairfield Industrial Park, LLC, acquired the property in April of this year. NAI Hanson has been managing the property since about a year ago, last autumn. For many years, the property was owned by Fairfield Park LLC, which has no ownership relation whatsoever to Fairfield Industrial Park LLC. They ran into financial problems, the bank foreclosed, the Superior Court appointed NAI Hanson as a receiver just over a year ago. They had no prior involvement with the property, started cleaning up the paperwork, which was a mess, and became aware that no CCOs had been issued for a number of the tenants. I believe it's been cleared up for a number of the tenants. However, in April of this year, Mr. Howard determined that CCOs could not issue for two long-standing tenants because they involve retail sales and/or services not permitted in the SED zone. One is Dory Stockoff LLC, doing business as Stockoff's Horseshoes and Supplies, which I believe has been there under current ownership since around 2011, and been there under prior ownership since around, for about 12 years. The other is the Actors Playhouse, which also precedes NAI Hansen's management and the current ownership. And the initial application was to legalize, so to speak, these two long-standing tenants. After the application was filed in June, an opportunity came to potentially lease another bit of vacant space to an entity known as OMGBYO LLC, which sponsors make-your-own pizza parties for children. So combined, these three uses involve roughly 11,700 square feet of the 164,000 square feet in the industrial park.
Did I hear that right? Out of the 160 some odd thousand square feet, this application only is referring to 11,700?
Correct,
Okay.
correct. So I think we'll start with Margot Kagan from NAI Hansen, who will explain the two of the tenants, one of the existing tenants and the prospective tenant. And then we also have a direct representative of Actors Playhouse who will go after that. So Ms. Hansen, Ms. Kagan, can you come up, please?
Mr. Tropley?
Could you raise your right hand, please?
You can sit at the desk there if you want, Mr. Snyder.
You swear the testimony you give this evening will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Yes, place your name on the record, please.
I'm Margot Kagan,
Can you please spell?
Kagan.
Ms. Kagan, you may have a seat there if you would like. The microphone's right in the middle of the table.
This should be able to pick us up,
That's picking you up, yes,
so I
sir.
can put this down.
Yes, sir.
My voice usually carries pretty well, and I think Ms. Kagan's does as well.
Yes.
Okay.
NAI Hansen got involved in this management of this industrial park in October of last year. I want to say the receivership was filed in September, late September, but we didn't really get our hands around things until October. Things were a mess.
Now, are y'all the owners?
No, we are not. We
You're
are
just
the
the acting
managing
managers.
agent for ownership,
Okay,
which is Fairfield Industrial Park.
okay.
At the time that we were brought on, NAI James E. Hansen, my parent company, the parent company to NAI Hansen Management, was the receiver, and they appointed, obviously, their managing company as the managing agent.
Okay.
When the property was purchased in April, the new owners decided to keep us on, as we were most familiar with the property at that time. Shortly before the sale of the property, we were notified through the Sellers Council that they wanted to have a meeting with Mr. Howard and the township to discuss the lack of CCOs. Unfortunately, prior ownership at that time was barred from conducting any business on behalf of the park, so that's when we stepped in. And we found out the prior ownership had not applied for certificates of occupancy, that only 2 tenants on the premises had certificates of occupancy in place, and that, there was a lot of inspection violations and things along those lines. At this time, I know of, we have gotten 8 COs for 8 of our tenants. We have 8 vacant units. We have 2 tenants who are part of this use variance. And we have 4 tenants that, although they've passed all their inspections, I haven't been notified of their COs yet. And I'm going to speak with the construction official this week to find out whether they've come or not. And we have 2 tenants that have not passed all their inspections yet.
But as far as the tenants that you're waiting for, they really don't need variances or
No.
anything from this
Nope.
board?
Nope, they're
Okay.
all, their use was approved.
Okay. Continue.
Okay,
And
so
tell us about,
Dory Stockoff is a farrier. They sell mostly to wholesalers horse products. And then those people sell to the end user. But even their quote-unquote retail sales might be to an individual horseshoer or veterinarian or something along, who's yet again selling to an end user, although they don't buy enough quantity to really qualify as wholesale sales. They've been in place there since 2011, I believe, is when their lease was signed. And the prior occupant of the space is the company they purchased, who was also a farrier operating in the same capacity. So they've been there since 2006. There's never been a problem. There's never been a complaint that I'm aware of. No one has brought to my attention any parking or just traffic concerns to me regarding their use of the premises. And that goes for also Actors Playground. And, you know, they also have very off hours, Actors Playground. They don't operate during the traditional times that the industrial use would be there. You know, barely overlapping because they cater to school children. Kids are in school during the day. So the use is, you know, from 2 to 3, till 7, 8, 9. I believe their last class is at 9. After school times, everybody else is leaving, the industrial use is leaving. So it's really, there's never been a complaint. There's never been an issue with any of the parking that we're aware of in our tenure with the property. So I don't see an issue as to those. The new application for OMG MYO. Oh my God, make your own pizza.
Before you move to that, the after-school deal, how long have they been in this building?
Oh, they've been in the premises, I believe their lease was signed in 2008.
2008?
So
They've been
9
there that long?
years. Yeah, they've been there a long time too.
Okay.
And
they're-
they have
they're- like
real
you said,
roots.
you testified that there never been a complaint.
That I'm aware of, I have not found in any of the history with the township, never a complaint by anybody about traffic or parking, or lots of complaints by the inspection officials that their violations weren't being addressed, but as you could tell, you could figure out by getting 8 CCOs, we have 4 tenants that have passed all their inspections, I'm just waiting for the CCOs. We have cured most, if not all, of those items.
Mr. Howard, not getting into violations as far as code violations or that, have there been any complaints?
Not that I'm aware of. Our system goes back several years digitally. There's nothing in the system. My review of the files didn't come up with anything either.
Okay, thank you. Yes, sir.
So, you know, with regard to OMG MYO, they intend to operate only on the weekends, between 12 and 7. It's when you have parties, birthday parties for your kids, you know, and you bring in a bunch of kids, and they're going to make their own pizza, and then they're all going to leave. Now, those type of parties, usually 1 or 2 parents stay, all the other parents are gone anyway. They're dropping their kids off at the birthday party. Same thing with Actors Playground. The parents don't stay in their cars. The parents drop the kids off. Actors Playground ushers them in. They take their class. The parent goes shopping somewhere else in Howell, whatever they do. It's my understanding Actors Playground has a nice connection with Howell Township. They do anti-bullying performances in your schools. They also help a lot of your students in the area get into, you have I'm not that familiar with Howell, I'm up in Bergen County, but you have a performing arts school, high school. They assist a lot of the students in their monologues, and that's mostly what they do is monologue work, helping people with auditions and things along those lines.
Now, how long have they been there?
That's Actors Playground has been there since 2008.
2008, okay.
The Make Your Own Pizza place is a
It's
proposed
the new
new
one
tenant.
proposed.
Right, it's the
Correct.
proposed new tenant. But obviously, the industrial tenants are not working, and any office tenants are not working on the weekends. So once again, parking is not an issue, traffic is not an issue.
Are you gonna have somebody testifying in a professional
Oh,
manner?
yes,
Oh,
yeah.
yes, two, we have two
I'm
professionals.
just
This is-
asking.
Yeah, this is
Yes.
just
Just
my
asking.
opinion as a
Yes.
property manager, right, yeah.
Yes. That's what we have for Ms. Kagan, if you have any more questions about
Any
Actors.
questions from the board? See, professionals. Matt,
I have one, you said, how many vacancies are there right now at the property?
There are 8 vacancies.
So based on the current state of the property, with the current number of tenants, with the current type of tenants you have, there are no, in your experience, no issues with parking, traffic, anything of
Right.
the like? Okay.
And we recently lost a significant percentage. So all this time prior, there was an additional 16,000 square feet of office space that was occupied, 40,000 square foot bakery production that was occupied. Still, as you said, no issues, no complaints. So even when we lease up those spaces, we don't foresee any difficulties because of the alternate timeframes.
right.
We have a professional who will also address parking.
Okay, now, when you say 8 vacancies, you have 8 vacancies now that could possibly become rented, correct?
Yes, they are primarily industrial space.
Okay, so it won't change from the industrial space then?
No,
Okay, it
no,
will.
that's
Okay.
not going to change.
Mr. San Clemente,
The horse product, what are their hours of operation?
Okay, they sent me, they operate 8 to 4, Monday to Friday, except holidays. They have 2 to 3 employees per shift. Their delivery schedule is as needed, for what they deliver to people, and it's a pickup truck, and they get 1 tractor-trailer delivery a week. They say probably 20%, 15 to 20% of their volume of, I guess, income is from quote-unquote retail customers. But once again, that retail customer is not the end user typically.
Now, these customers, do they bring in trucks to pick
No.
up?
I go in
A
my
pickup truck,
to get-
maybe.
I get my horseshoes there.
Okay. Thank you.
Okay. Is that it?
Yes.
Mr. Chair, if I may, I'm sorry.
Sure.
One quick question. For the Actors Playground, I know you said they work with schools. Do they have school buses
No.
dropping off the
They go to the
kids?
school to do anti-bullying performances in Howell Township.
Okay, thank you. And for the proposed pizza party use, I believe the testimony was given that the parents will come and drop off and...
Well, that's my experience from being a mom. If
Okay.
I was taking my kid to that party,
Okay.
I'm not gonna stand around and make a pizza with a bunch of 7-year-olds. I'm gonna let the parent who's throwing the party take care of all that, and I'm gonna go shopping, somewhere else. I'm gonna get groceries for the week, and then I'm gonna come back and pick them up.
Understood. So what I'm trying to get at is there a specific pick-up and drop-off area for this
Yes,
kind of facility?
Each of the units have a front, this particular unit is in Building 6, so it has a front door entrance with a sidewalk in front of it.
Okay, thank you.
Mr. Snyder, you're gonna have somebody testify
Yes,
to the
yes.
traffic patterns?
Yes.
Okay.
Yes.
That's it, thank you.
And next I'll call Ralph Calabino.
It's COLOMBINO.
Very well, thank you. Your witness?
And Mr. Calvino,
You can have a seat.
have a seat.
Thank you.
Can you explain your relationship with Actors Playhouse?
It's actually called Actors Playground.
Sorry.
No, that's okay. It's said that way a lot. But it makes it sound like we do plays, so we don't do performances on site. I'm the artistic director and I'm the sole owner. We've been in business for 12 years. And primarily we educate young people in the art of acting. We have basically, I'd say between 8 and 12 students to a class. It doesn't start until 4 o'clock. And our last class starts at 9. And primarily, we have a lot of kids in the industry too. We're not management. We use some of New York's best agents and managers to send our kids through, and we assist those kids in that by helping them with auditions and things like that. But on the other end of it, we're more about the education. We do a lot of work with the kids from all the Howell elementary schools, middle schools, and the high schools. And plus, we do travel to schools and do anti-bullying as well.
And number of employees you have on site when you're in operation?
Well, I'm the only employee. The rest of my employees are independent contractors. But usually we'll have myself and then 2 other teachers.
And how many students typically at a time?
Like I said, only about 8 to 12 at a time. We have about 14 different classes, so we break it up. Any more than that, and the child won't be able to work in class. So we like for every single class to not to be overloaded, because it's not fair to the student.
And you're sometimes there in the evenings. Is the lighting adequate by your entrance?
Yes, and I make sure of it. I'm pretty diligent about that. There is always proper lighting, and the parking area is right in front of our door, so there really isn't. And plus, I always have my assistant Rich, who is always sitting at the desk, and when students come in, he ushers them inside.
And do you have anything further to add that Ms. Kagan hasn't already commented on?
I will just say that even though it is acting that we are teaching, which is rare, and I run it a lot different than a dance school. It's very different. There are some kids that come to us because they want to go into the art. But there's other kids that come to us because they don't have a place. They're being bullied, or they're misunderstood, or they're not into sports, and they find their place with us. Some of them become filmmakers, some of them become actors, some of them have even become producers. And some of my students have even become agents and managers. I myself have been teaching for 30 years. But the school, it took me a long time to build it because it's something very unique. But I have to say, a lot of it is because of the belief that a lot of parents have had in us. A lot of the kids and the parents call our classes Confidence 101. And a lot of our kids, my main point is a lot of our kids are coming to us for confidence and to find out who they are. And we're very patient. A lot of our kids, if they come to us if they're 7 or 8 years old, we have them until they graduate high school, and some of them even stay with us beyond that. It really doesn't matter what their goal is. It becomes our goal, and we try to help them with it.
Have there been any parking issues during your tenure there at Fairfield Industrial Park?
None at all. There's plenty of parking, and most of the businesses are gone. Or they're not operating when we operate too. But we get along with our neighbors really well, too.
I have nothing further for this witness. Thank you very much.
Any questions from the board?
Yes, you said the first class starts at 4 PM. How long do the classes run?
Usually 90 minutes.
Right, so 9 o'clock, 9 o'clock starts, so around 10:30, that last class is ending?
Yeah, I would say that is the night of the adults. We have an adult class that comes in Wednesday night, and that ends a little late, but other than that, that's it.
So then the adults have plenty of parking?
Oh, yes.
Okay.
That class is only about 12, too.
But, thank you.
To your best of your or knowledge, is there any residential houses around you?
No, we're actually in Building 7, which is on the other side of, I guess, Building 6. So we're more in the middle to the back of the park. We're near the pond area and all that. Well, we're close. The pond is on the other side of the building, but there's no direct road right there.
Okay.
So it's kind of hidden.
Any other questions of the board? Professionals?
No questions.
Okay, thank you.
Next, we'll have Scott Kennel.
Thank you.
Thank you, sir.
I do. Scott Kennel, Kennel, with McDonough and Ray Associates, 1431 Lakewood Road, Manasquan.
Mr. Kennel, could you briefly give the board your professional background?
Yes, I'm a principal with McDonough and Ray Associates. I have over 35 years of traffic and transportation planning experience. I've appeared before this board on many occasions, as well as 100 other municipalities over the 35 years. And I'm qualified as a traffic expert by New Jersey Superior Court on 3 land use matters as well.
Education?
Education, I attended New Jersey Institute of Technology.
Thank you, sir. And yes, you have testified before this board many times.
So he's accepted as a...
Yes, sir, we accept him.
Mr. Kennel, let me know when you'd like to refer this exhibit, but why don't you tell us about the investigation that you've done as it pertains to parking and related issues at the facility?
Yes, so I'm very familiar with this park. I mean, I'm familiar with it for over 30 years, and just with my experience in the area, working in Freehold and in Monmouth County, and on a general basis, I've never noticed a parking issue there at this location. But what's unique is it has, as it stated, there's 9 buildings, a total of 164,000 square feet, and there's multiple types of uses which have different parking characteristics. But specific parking accumulation studies were conducted in October and November of this year, and at that time, there were approximately 60,000 square feet of the total 164,000 occupied. As was mentioned by Ms. Kagan, probably 30 days prior to that, or a month or 2 prior to that, there was probably another 60,000. But at the time of our data collection, approximately 60% of the office park was considered vacant. There are over 460 parking spaces within the park.
Now, let me, how did you determine that?
It was a combination, it was basically an inventory conducted by my office as far as recording the number of parking spaces and review of the as-built survey and the parking layout that's provided for each building.
Let me just mark this as, I guess, A10 would be what we mark next?
A10.
And perhaps you could show it to the board. I could make myself useful and function as an easel.
Just set it right there on the edge of the table there, Mr. Kennel.
Thank you. For the board's benefit, again, A10 is an aerial of the industrial park. The bottom of the page, or the aerial, is Route 33. And then to the right is Howell Road. If you're familiar with this site, it has three full movement access points to Route 33 and a full movement driveway to Howell Road just south of the signalized intersection with Route 33. As I stated, there are approximately 460 parking spaces throughout the site, and we've numbered the buildings here. 1, 2, and 3 are in the quadrant closest to the Route 33 and Howell Road intersection. And then as we work in a easterly direction, there's Building 4, Building 5, Building 6 is the most southerly, or I guess easterly building, and that's where the OMG use is proposed. And then to the west of that is Building 7, and that's the location where the two existing non-permitted uses are occupied. And as it indicates, there's extensive parking provided to the west of Building 7. And then further west is Building 8, which is the largest building on the site, and that is currently 100% vacant. That was the manufacturing facility previously. And then Building 9 is the last remaining building, again, towards the westerly direction towards Howell Road. And that is, has tenants that occupy that building. Parking counts that were conducted over 4 different days in October and November. On November 1st, which is a Wednesday, we conducted traffic counts from 12 o'clock till 6 on a 15-minute basis. And it showed that the peak parking number of vehicles parked on site was 108 vehicles. Again, there's 460 parking spaces throughout the park. And that worked out to, when you compare it to the number of occupied spaces, occupied building areas, to a parking rate of 1.7 per 1,000 square feet. The park itself, as a total, provides 2.8 parking spaces per 1,000 square feet when you consider the 164,000 square feet of building area. So the current peak demand is much less than the supply at the rate of 1.7. Now, I'm sure many of the board members are familiar with the site, and when you visit it, that there's always been availability of parking throughout. What is important to recognize as far as the 3 uses, the first use that was mentioned, dealing with the horseshoes and Equine products, they have approximately 5,100 square feet, but as was indicated, the employees that utilize the space is anywhere from 2 to 3. I would qualify that more as a specialty retail, and as was stated earlier, rather than general retail, as the parking rate that was applied to that space in the planner's report. And again, the demand that's used for, which would translate in the need for 34 parking spaces for the Dory stock-off space. And based on the current tenant and the type of operation, they clearly do not need the 34 parking spaces that it was identified in the planner's review. As far as the Actors Playground School of Theater that occupies Building 7, again, by ordinance, it's suggesting that 29 parking spaces are required. As was indicated, the parents typically drop off their children, and if there are parents there, it's for a short duration for either the drop-off or pickup, and that there's never the need for 29 parking spaces to support that use.
How many parking spaces are there conveniently located to Building 7 where those 2 uses are?
Well, according to the planner's report and the uses considered for Building 7, it was recommended that 80 parking spaces are required. there are at least 100 parking spaces that are conveniently available to Building 7. So therefore, based on the type of operation, the current parking practices that exist there, where today the maximum number of parked vehicles there is approximately 35 vehicles, there are more than enough parking spaces to support those two non-permitted uses for Building 7. As far as Building 6 is concerned, and the proposed non-permitted use, the OMG, Building 6, according to the planner's report, should provide 85 parking spaces. There are at least 100 spaces, if not more, that are conveniently accessible to that building. And based on the parking supply as well as the time of its operation, that is a compatible use for the industrial park, and would not expect any problems with providing the adequate parking, and will have minimal impact on the operations of the park.
Mr. Kennel, I want to interrupt you here. Mika, whenever you figured your calculations, were you taking in consideration what could be there and the amount of parking spaces that would be required?
Yes,
Not necessarily for the tenant that's there, correct?
Correct. I basically applied, when it's a retail use, I applied it for retail requirement, not specific to the specialty retail that's there. It's a generic retail.
Okay, so in your opinion, if these tenants were to move out and they went to a full-blown retail, they would have adequate parking spaces?
Well, I did try to count how many parking spaces are there, and based on the site plan that was provided to us, and what was testified today, I'm not sure of how many parking spaces are actually there, so I can't really clarify if that's adequate. But based on the expert testimony that's provided today, it appears that there would be enough spaces available.
That's all I wanted to find out. Mr. Kennel?
Do you have anything further?
That's all. I mean, it's again, these three non-permitted uses will occupy approximately 7% of the total floor area. It's a shared parking phenomenon that takes place because of the type of uses. And based on our observations and my 30 years of knowledge of this park, I'm of the opinion that they will not have a negative impact on the parking needs of the industrial park.
Thank you, sir. Do you want to kind of wrap it up at this time?
Well, I was going to put on a planner.
Sir?
I have one more witness. I was going to put on a planner just to.
How long?
I think 5 minutes,
Okay.
just dotting the i's and crossing the t's here.
Board okay? Okay. Okay,
Andrew Janev?
go ahead, Mr. Snyder.
Good evening.
Swear testimony that you're giving tonight will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Yes, state your name for the record.
Thank you. It's Andrew Janu, Janiw.
Very good, thank you.
Could you briefly state your professional background, Mr. Janev?
Certainly. I have a bachelor's and master's degree in civil engineering from the New Jersey Institute of Technology. I am a licensed professional planner in the state of New Jersey, and I've been a principal in the firm of Beacon Planning and Consulting Services since 1997. I'm also a member of the American Institute of Certified Planners, currently serving as the planner for the Borough of Carteret in Middlesex County, Borough of Neptune City here in Monmouth County, redevelopment planner for South Amboy. I've appeared before this board and throughout the state of New Jersey.
We accept your credentials, sir.
Thank you.
So the application is for a use variance relief, and could you analyze it for us and give your opinions as to whether the statutory criteria are satisfied?
Certainly. In preparation for this evening, and in order to justify the use variance for these, for this site, I did review your ordinances, your master plan. I've been out to the site many times. As a matter of fact, I was employed at an office at this site 1992-93 when it was fairly intensely operating. And I will say I've never had a problem parking going back as long as my history goes with this property. But having said that, this property is within the Special Economic District. It is the SED zone.
That district permits offices, financial institutions, medical centers, warehouses and distributions, manufacturing, multipurpose recreation and sports complexes. And interestingly enough, a permitted accessory use to the industrial facility is retail sales, with the caveat that provided the percent of floor area devoted to the retail use shall be limited to 1,000 square feet or 5% of the gross floor area. So if we look at the 164,000 square feet, if we're a single user, there's an expectation within the ordinance that as much as 8,200 square feet of the space can function as retail accessory to the distribution. So the introduction of retail here is not foreign, and I'll get to that a little bit when we go through the Medici criteria. We also looked at your master plan and how your master plan has treated this property. Over the years, 33 has been recognized as a commercial corridor. It's also recognized within your master plan that the utilization of Highway 33 has expanded to now where it would be considered to be a more intense commercial corridor, and in fact, there are recommendations throughout your master plan that some of the uses should be revisited as Route 33 develops, and perhaps the introduction of certain retail uses would be ideal within this corridor. The infrastructure is there, it's ideally located, and the area around it is developing commercially. If we look at the adjacent property uses to this facility, across the street we have the Wawa with gasoline that was added after the convenience store was erected. Behind the property, we have the Landex Nursery, which it not only functions to grow nursery stock, but also sells nursery stock retail. You have other light industrial parks in the vicinity, and there's a pool club in the vicinity. And as a matter of fact, prior to the expansion of Howell Road, there was a deli directly across the street on this property at that intersection with 33 and Howell Road. So it's not foreign to have this type of intermingling of uses here. Going directly to the requirements for the use variance, this would be treated under the Medici criteria because this would be these uses have been characterized as principal retail uses. So whether we're looking at Dory Stockhoff or the Actors Playground, both those are existing here, and they've been characterized as retail, general retail. We've heard testimony about the peculiar nature of each of these uses as to why they're not pure retail. And I'll get into that a little bit more, but what we are seeking then is a use variance for the two existing uses that have been here for quite some time, as well as the introduction of the pizza party facility with this location, for a total of roughly 11,700 square feet of what would be characterized as retail of the 164,000 square feet. So under the Medici criteria and the D1 variance, we have a couple of different options that we need to look at as a planner. In this case, what we should particularly focus upon is the particular suitability of the site for this use. And when we're looking at particular suitability, we're looking at why these uses would be ideal and particularly adaptable to this site. So the site is along a highway corridor. It is in the proximity of other retail uses. And the fact is we have a history, as opposed to looking at it theoretically. We have two of these facilities that have been operating and functioning at this site in varying intensities of uses in terms of the operation of the overall site, with no record of any conflicts or problems. We have the Actors Playground, which operates at hours that are absolutely complementary. One of the planning concepts that's been going on for some time now, and I think is actually appropriate to look at, is having uses within such facilities where there's shared parking. When you have properties that have complementary hours, especially when you have some day uses, some evening uses, there's no reason to overpark, to overpave facilities. We don't plan for the Christmas rush in such facilities when we know that there are facilities such as Actors Playground or the OMG MYU facility that are going to operate as off hours. And certainly that's something that's been proven here. Actors Playground operates evenings, potentially weekends. OMG MYO would only operate on weekends when a majority of the other tenancy in this facility would not be here. With respect to the Dory Stockoff, that is a specialty space. It's actually quite a bit of space, 5,000 square feet, for the intensity of the population of it. We have 3 employees there and very infrequent visitors by people that are picking up, mostly for resale to other farriers or to someone who's doing the horseshoe. So in terms of complementary use patterns, I think that goes to speak directly to the particular suitability of this site in terms of having other uses that have normal business hours, perhaps 8 to 4, 8 to 5 o'clock. These, 2 of these 3 uses having complementary uses, the other not being anywhere near the intensity of what a straightforward retail use would be. Having said that, should these facilities be replaced with pure retail uses, we've heard testimony from Mr. Cannell that there is more than adequate parking available in this facility. As a matter of fact, the facility is significantly underparked in terms of what he's experienced out there. That's been my experience with this facility over the years, and I think certainly it can be accommodated here. With respect to the negative criteria, we have to look at whether this undermines the purposes of your land use plan or your zoning ordinance. Again, the zoning ordinance does have a carve-out for retail as an accessory use here, so the introduction of retail is not foreign to this facility. I certainly think that while this is not accessory retail space, it can be accommodated given the size and complexity of this facility and the overall park, and shouldn't be a detriment to this. And given in light of the master plan comments regarding the introduction of a variety of other uses that would promote economic growth to Howell Township, and perhaps considering additional retail uses along the 33 corridor, it is consistent with your long-term planning for the facility. Finally, in terms of reconciliation of the Medici criteria as to why the retail use was omitted, it hasn't been entirely omitted. It's considered as accessory. And there are recommendations to revisit this site, and I'm certain within the next coming years, as your master plan continues to grow and to be fine-tuned to the way Howell's growing, that there will be other considerations for uses. So in terms of the criteria under Medici, I certainly believe the application before you meets this. I don't think granting these use variants would be detrimental to anything in Howell. It is a commercial corridor. And quite frankly, we're seeing commercial uses changing. Retail in and of itself, we're seeing malls going empty and dark. We're seeing strip malls struggling. We're seeing this industrial park struggling in terms of being able to replicate office and former industrial and manufacturing uses here. I think it's a good reuse of the property, and I certainly think the property can accommodate the use without creating any nuisances, given its distance from any residential properties and its proximity to other facilities that are very similar in nature.
I have nothing further for Mr. Janu.
Board, do I have any questions?
Mr. Janu, the new proposed business, how many square feet is that taking up?
I believe that's 2,800.
3,600.
3,600, excuse me.
3,600 square feet? Because it says, and you said about the retail use, shall be limited to 1,000 square feet or 5% of gross floor area,
That's as an accessory to other uses.
whichever is less.
1,000 per user would be the cap. And again, I'm interpolating. If this were a 164,000 square foot user, that user would be permitted to have 5%. Whatever's less. So you'd have to have multiple users to accommodate it. However, having said that, it's interpolated that however it could happen, retail is not foreign. My point was, retail is not a foreign anomaly to this zone. And in fact, this site can accommodate it given what we, the primary concern again with retail would be the intensity of utilization, parking requirements and the like. I think Scott's demonstrated that circulation-wise it can be accommodated. There's plenty of access points around 33 to accommodate without creating any conflicts internally. And certainly more than ample parking available within this facility to accommodate the retail that's being proposed this evening.
Okay, thank you.
Any other questions on board? Professionals?
The only comment I have, is there any possibility of consolidating the lots? Or is it in so many different names?
My understanding is that.
Need to come forward, please. Get
that
on the mic.
Fairfield?
Yeah, you gotta be on the mic for the
My
recording.
understanding is that Fairfield Industrial Park LLC owns both lots. So it's a consolidation, if it's a matter of, you know, that's what we need to do to get this done and approved, we're willing to do it, is my understanding from ownership at this time, but it wasn't necessarily something we were planning to do.
Well, it can be done by deed, too, you understand that?
I don't know what that
Okay, yeah.
means,
Well, I mean,
but,
it's not-
okay.
You're not preparing a subdivision map come to the board, it can be done by deed.
Okay.
And if it's possible, it's in the same, usually I ask to consolidate, if I have unique properties like this, you can put it into one lot. You have no problem if it's a condition.
Well, I do not believe it will be a problem with ownership if it's conditioned.
Okay. And I have no further questions.
Okay, Mika?
I have no questions for this
Okay,
witness.
Matt? Okay, any further from the board?
So at this point, we respectfully request that the application be granted, and also thank you for first extending it to 11 and now extending us to a little bit after 11.
Okay, the board, we need to open the public.
Mr. Chairman, the only thing I comment, should the board look favorable, it's only for these three users.
Correct.
Okay.
That's all, that's what the application's for, is three users.
Well, there was a paragraph in there for requesting about future users, and I think you gotta deal with each one individually.
Right, that's correct. If they, correct me if I'm wrong, but if they change uses in there, it still has to go through a CO and at that time, if it's not a permitted use, they're gonna wind back up here.
Well, there was a question about granting something for future users, and
No,
I
it doesn't work.
Unless you know what the use is, I don't think
It
we
still
can do
goes through the CO process.
Right.
And if they're not permitted uses for that building or a continuing use of a non-conforming use, then they would wind up back here, if I'm correct. Okay. Understand that, Mr. Snyder?
I understand, yes.
Okay. Any further questions or from professionals in the board? Need to open to public. Can I have a motion?
Motion.
Motion by Mr. Merton,
I'll second.
seconded by Mr. San Clemente. All in favor?
Aye.
All opposed? Anyone from the public at this point will take questions and comments. Seeing none, can I have a motion to close?
Motion to close?
Motion by Mr. San Clemente. Seconded by Mr. Armada. All in favor?
Aye.
All opposed? Okay, is there, you like to do a summation?
I think I did, I just
Okay.
respectfully
Just wanna
request
make
that
sure.
the application be approved for the reasons that you've heard from the testimony of the witnesses.
Okay. What's the pleasure of the board?
Members of the board, it's not the issue for these two businesses that the COs weren't granted and the issues that looks like they ran into. As far as the facility, looks like they've been there for many years and have been operating without any issues. And also this new application coming in, while the SED really doesn't permit businesses, but there is a retail part to it. And really it doesn't conform because of the square footage and so on, but it is something that's on the weekend. And also taking into consideration the whole facility is really not being intensely used. I'm going to make a motion to approve, to allow these two existing businesses to continue, and for the new application, that it could go in on the weekend, and also to have the consolidation to one lot, if it can be done.
Okay, I will look into that process.
Okay.
Have a motion by Mr. San Clemente. Do I have a second?
I'll second that motion. I just have a question. I heard one person say 3 businesses and another, Mike said 2 businesses. Which is it, 3 or 2?
It's 2 existing businesses.
2 existing,
And 1 new one coming in.
And one
That's
new one
3.
coming
It's a
in.
total of 3.
okay.
There's
So-
non-conforming.
I find that the 3 businesses are inherently beneficial for the community. The use is very light. The suitability is fine for the area, and I second the motion to approve.
Okay. Can we have a roll call, please?
Mr. Armato?
Yes.
Mr. Mertens?
Yes.
Mr. O'Donnell?
Yes.
Mr. Posh?
Yes.
Mr. San Clemente?
Yes.
Mr. Turk?
Yes.
Chairman Nansen?
Yes, and further finding of fact on that is that based on the testimony that was provided, based on, there's no change of use, that's what's existing and what's permitted now, my vote was yes.
Thank you very much.
Thank you.
Thank you.
Board members, I gotta thank y'all very much. I really appreciate you doing this.
I thank you too, because it gets something on my desk.
Thank you for staying so late.
You're welcome. And
Yes, I'm sure.
is there further business of the board? Seeing none, can I have a motion to adjourn?
Motion to adjourn.
Motion by Mr. Bloom,
Second.
second by Mr. O'Donnell. All in favor?
Aye.
All opposed? Zoning board adjourns 10 after 11.